Senate will come to order. Mr. Schauffele, please call a roll.
Senators Amabile, Baisley, Ball, Bridges, Bright, Carson, Catlin, Cutter, Danielson, Doherty, Exum, Frizzell, Gonzalez, Henriksen, Judah, Kipp, Kirkmeyer, Kolker, Liston, Lundeen, Marchman, Michelson Janae, Mullica, Pelton B, Pelton R, Rich, Roberts, Rodriguez, Simpson, Snyder, Sullivan, Wallace, Weissman, Winter. Mr. President.
Let's do this. The morning roll call is 35 present, 0 absent, 0 excused. We have a quorum. Senator Pelton B, would you please lead us in the Pledge of Allegiance?
Please stand with me for the Pledge of Allegiance. I pledge
Thank you, Mr. President. I move that the Senate Journal of April 23rd, 2025 be approved as corrected by the Secretary.
You've heard the motion. All those in favor say aye. Opposed, no. Oh, the ayes have it. That motion is adopted. Senate Services.
Correctly printed, Senate Bill 305, 306, 307, and 308. Correctly engrossed, Senate Bill 132, Senate Concurrent Resolution 2, Senate Joint Resolution 22. Correctly re-engrossed, Senate Bill 121, 130, 162, 278, 283, 287, 291, 293, and 294. Correctly revised, House Bill 1004 and 1207. Correctly re-revised, House Bill 1023, 1136, 1176, 1222, 1236, 1244, 1245, 1294, and 1307. Correctly enrolled, Senate Bill 2, 212, 214, 226, 228, 254, 257, 258, 261, 262, and 270. Senate Joint Resolution 17, Senate Resolution 11.
Committee reports.
Committee on Health and Human Services, after consideration on the merits, committee recommends the following. Senate Bill 289 be amended as follows, and as so amended be referred to the Committee of the Whole with favorable recommendation and with the recommendation that it be placed in the consent calendar. Committee on Transportation and Energy, after consideration on the merits, the committee recommends the following. House Bill 1260 be postponed indefinitely. After consideration on the merits, the committee recommends the following. House Bill 1277 be postponed indefinitely. After consideration on the merits, the committee recommends the following. House Bill 1177 be referred to the Committee of the Whole with favorable recommendation and with the recommendation that it be placed on the consent calendar. After consideration on the merits, the committee recommends the following. House Bill 1281 be referred favorably to the Committee on Appropriations. After consideration on the merits, the committee recommends the following. Senate Bill 299 be amended as follows, and as so amended be referred to the Committee of the Whole with favorable recommendation. Committee on Judiciary, after consideration on the merits, the committee recommends the following. House Bill 1026 be amended as follows, and as so amended be referred to the Committee on Appropriations with favorable recommendation. House Bill 1049 be referred to the Committee of the Whole with favorable recommendation and with the recommendation that it be placed on the consent calendar. House Bill 1275 be referred favorably to the Committee on Appropriations. Senate Bill 300 be referred to the Committee of the Whole with favorable recommendation and with the recommendation that it be placed in the consent calendar. House Bill 1183 be amended as follows, and as so amended be referred to the Committee of the Whole with favorable recommendation. Senate Bill 304 be amended as follows, and as so amended be referred to the Committee on Appropriations with favorable recommendation. Committee on Education, after consideration on the merits, the committee recommends the following. Senate Bill 284 be amended as follows, and as so amended be referred to the Committee of the Whole with favorable recommendation. House Bill 1149 be amended as follows, and as so amended be referred to the Committee on Appropriations with favorable recommendation. House Bill 1167 be referred favorably to the Committee on Appropriations. Mr. President, the Committee on Education has had under consideration, has had a hearing on the following appointments, and recommends that the appointments be placed in the consent calendar and confirmed. Members of the Board of Trustees for Fort Lewis College for terms expiring December 31st, 2029. Jordan Dresser of Fort Collins, Colorado to serve as an enrolled member of federally recognized Native American tribe appointed. Jill Hawley of Centennial, Colorado appointed. Julia Duval of Lakewood, Colorado, appointed. Mary Ribideau of Durango, Colorado, to serve as a resident of Southwestern Colorado, reappointed.
Message from the House. We're dying over here.
The House has passed on third reading and transmitted to the Revisor of Statutes House Bill 1269, amended as printed in House Journal April 22nd, 2025, and amended on third reading as printed in House Journal April 23rd, 2025. The House has passed on third reading and transmitted to the Revisor of Statutes House Bill 1315, House Bill 1319, House Bill 1153, House Bill 1122, House Bill 1268, House Bill 1271, House Bill 1057, House Bill 1302, amended as printed in House Journal April 22nd, 2025. The House has passed on third reading and transmitted to the Revisor of Statutes Senate Bill 70, amended as printed in House Journal April 22nd, 2025. The House has passed on third reading and returns herewith Senate Bill 36. The House has adopted the first report of the First Conference Committee on Senate Bill 268. The House initially failed to repass Senate Bill 268. Upon reconsideration, the House repassed Senate Bill 268 as amended by the first report of the First Conference Committee.
Message from the Revisor.
We herewith transmit without comment as amended House Bill 1057, 1122, 1153, 1268, 1269, 1271, 1302, 1315, and 1319. Without comment as amended, Senate Bill 70.
Special orders, second reading of bills. Majority Leader Rodriguez.
Thank you, Mr. President. I move to lay over special order second reading of bills until Friday, April the 25th.
The motion is laid over special order second reading of bills, so calendar to Friday, April 25th, 2025. All those in favor say aye. Opposed, no. Special order second reading of bills calendar will lay over until Friday, April 25th, 2025. Third reading of bills. Final passage. Mr. Schaffler, please read SCR 25002.
Senate Concurrent Resolution 002 by Senator Danielson and Michelson Janae and Representative Duran, submitting to the registered electors of the state of Colorado an amendment to the Colorado Constitution concerning allowing Colorado lawmakers to pass laws that permit victims of childhood sexual abuse to bring a civil claim for the sexual abuse regardless of when the sexual abuse occurred.
Senator Danielson.
Thank you, Mr. President. I move SCR 25-002, the Child Sexual Abuse Accountability Amendment, on third reading and final passage.
Discussion. Senator Danielson.
Thank you, Mr. Chair. Thank you, colleagues. I keep this picture on my phone these days. It's this really cute picture of my kids from Easter. It's pretty adorable.
It's adorable.
And I look at it, you know, during the day, especially when we're having some tough debates, because they bring joy to my heart. And it was really, really tough to leave them today. My daughter is 7. Some of you know her because she was here a lot when she was an infant, crawling around the house floor and just being part of our work. And she's grown now. She's 7 years old. And my son, who was born kind of during COVID, so you probably know him less, but Callum's 3. He'll be 4 in December. And now that I know the survivor community so well from the last 5-6 years, they are the same age as many of my friends when their abuse started. 3 years old. 7 years old. And I know that every one of you has a Callum and an Izzy in your life. I hope you're that lucky. I think you all are. Grandparents of, or neighbors to, or aunts of, uncles of, grandparents of, parents of, friends of, an Izzy or a Callum in your life. And for all of those little kids out there, this is why we're bringing it forward. Again, to give this body the chance to do the right thing. I want to thank you all, my fellow senators, for getting us to the cusp of taking a significant step forward for healing the trauma of sexual abuse survivors. Today needs to be about the survivors. We heard their stories and we listened to their pleas, and we know what we must do. We heard the compelling testimony from so many Coloradans, from all walks of life, from all over the state. We heard one from Angie Witt, that was especially memorable. A survivor of sexual abuse, she's been consistent in her pursuit of justice, but has had to wait for the state to say, "We've had enough." She asked this of us in her testimony here. She says, "Please do not silence the voters of Colorado as I was silenced." We are poised to take the necessary action to keep kids safe. We can prevent child sexual abusers from causing further harm. The passage of this measure will bring Colorado in line with the 27 other states that already refuse to allow these abusers to avoid accountability. The goal of this effort is to shift the burden off of the victims of sexual abuse and the Colorado taxpayer and put that burden on the predators responsible for the abuse and the institutions that covered it up. If we do not pass this amendment, it is impossible to hold these institutions and these vicious predators accountable. I ask you to vote yes to bring us one step closer to real accountability for survivors of childhood sexual abuse. Thank you.
Senator Michaelson Janae.
Thank you, Mr. President. I want to thank my co-prime sponsor, the senator from Wheat Ridge, the good senator from Wheat Ridge, for constantly standing up for the survivor community and fighting as you are a member of that community. And I am grateful to be able to work on legislation with you. This is hard, it's personal, and I talked about it yesterday. I don't know that I feel like I can talk about it again today. But I will tell you, as a victim of child sexual assault, that my story is different than many of the stories that we hear. I was assaulted when I was 7, and I was assaulted when I was 14, but I was saved from the constant repetitive assault that we heard from our victims. And what we heard from our victims makes my skin crawl every single day. And I can't stop hearing their testimony over and over again. I feel like what we're asking for is reasonable. It is simply permission to go to the people and ask them to tell us whether or not we can have this debate. We're not laying forward any policy in the amendment. It's a simple request to please let us have the conversation. And I am speaking from the bottom of my heart when I ask for you to deeply consider whether or not we can have that conversation. There are so many people that are impacted. They are real people. They are human beings just like me and you. We know them. We don't know them. There are many people who still have yet to come forward. This is the time to be able to turn back the clock and give a moment of grace to the victims of a horrific, horrific assault. I ask for your aye vote.
Further discussion? There is further discussion. Senator Weissman.
Thank you, Mr. President. Members, I just wanted to add my own gloss or thoughts on this subject because I have a history with it in this building. Interesting to situate this subject compared to some of the discussion that kept some of us here until pretty late last night in judiciary. We were talking about other policies and how the state can grapple with some problems we've had in delivering criminal consequences to those who commit sexual assault or other sexual abuse. We're talking here about civil remedies. which, look, when these things happen, there need to be appropriate criminal consequences, but I think a lot of survivors would tell you that those are important, but that's not really what healing is made of. That's where the civil side of this comes in. So I thought I would talk about the law of this briefly, and then more importantly, the ethics of it. We're here at all because we are not like all of our other sister states in even having the language in the Constitution that we are here to invite members of the public to possibly consider amending. We have specific language limiting us as a legislature from passing laws that are retrospective in nature, Article 2, Section 11. Not every state constitution has that. As a result, some states already have the laws that it is the purpose of this measure, if approved by us and the House and the voters, to even allow us to begin discussing the sideboards of. So at the best here, we seek to join the company of other states. We're not doing anything really novel here. The way that the existing law has been interpreted is that when a civil statute of limitations runs, there's a vested right in this case, an offender, an abuser. A vested right is a legal term. What it really amounts to is the ability to escape accountability for something that you've done or been part of covering up. How we got here is that after many, many years, we all debated, those of us who are here anyway, debated and passed Senate Bill 2188. And that provided a civil remedy framework. There was a look-back window. There were some caps. There were other details that were heavily negotiated at the last days of session. We did that because then existing case law from our Supreme Court interpreting our state constitution said, you know, we have this bit about retrospective laws, but there is a public policy exception or an ability for the legislature to proceed in narrow circumstances. So that's what we sought to do in SB 88 that year. As you heard, some folks attempted to then seek redress under that mechanism. A couple years later, the Supreme Court said, well, no, actually, there is not such a public policy exception. Your law is unconstitutional to the extent that it is retrospective. Door slammed in the face of survivors of childhood sexual abuse. The court specifically said the people have to take this up. As noted, there are two pathways to that. Folks can gather petitions, or with 2/3 in each chamber, we can pose the question to our constituents. So here we are with SCR 002. Now, every lawyer in this room, and a lot of non-lawyers, I think, appreciates the significance of a statute of limitation. We don't depart from them casually. Why do we have this conversation here? Because I think what we're talking about is different. It is customary in the law, civil or criminal. The more serious is the offense, the more complicated, the longer is the statute of limitation. The problem with childhood sexual abuse, especially when it is in an institutional context, when there is institutional level cover up, as we know that there is, we all read the papers. The average age of someone coming forward as a survivor to even begin to talk to their peers is about 52. I haven't even gone around the world 52 times myself. Some of the folks who testified in committee previously shared their age with us, and one woman was in her 40s. I thought, wow, you're beating the average. You're only 47, 48 coming here talking publicly about what all you've gone through. So that's why. That's why other states have seen fit to provide these remedies for decades old, often serial, covered up abuses. So much for the law. Now what about the ethics? Why are we even talking about civil remedy? Why is criminal not enough? You know, members, when we talk about suing, when we talk about damages, when we use the dirty words of private right of action, like, it seems to be touching some third rails in here, but, and I appreciate the senator from Wheat Ridge noting this, what this is about is simply making sure that those who do wrong, in this case, sick, twisted, grievous wrong, bear the cost of it. Because if that doesn't happen, then everybody else bears the cost. The survivor bears the cost. Maybe their family. You know, to the extent that insurance does isn't present to cover treatment. Now that's cost shifting. We talk about that in the healthcare context. The basic premise of civil law, of actions that are of a tort nature, is to assign the cost of harm to those who've done the harm. It's very fundamental, and I think very simple. And I think that we all believe in personal responsibility, regardless of our party. So at the end of the day, this is about personal responsibility and organizational responsibility. There are organizations that, by their nature, bring together adults and kids, often wrapped in a fabric of assumed trust. And in that trust is vulnerability and sometimes predation and harm. So what does the harm look like? Therapy, maybe for years and decades, counseling. If you know anything about how this kind of survivorship goes, you might know about alcohol use and abuse, drug use and abuse, eating disorders, things that are pretty hard to recover from. Again, who bears the cost of that? Does the survivor bear the cost, or does the offender bear the cost? The law uses the words pain and suffering sometimes. How do you even put words on what it is to go through this type of experience? But we have to put words on them sometimes, so we use words like that in the law. Pain and suffering. What that really amounts to is years, maybe decades of your life that you'll never get back. That's really what we're talking about here. Kids start out innocent, they're grown up, they're figuring out the world, then this stuff happens. And the course of their life has changed probably forever. I know an elder out in my community who was a survivor of childhood sex abuse. He's probably pushing 90. He still comes to meetings about this. He still talks about it. He still hopes this place will do something. 90 years old, think about it, looking back on almost your whole life. Some words came back to me from a meeting I had long ago with a survivor of a different kind who characterized survivorship this way. It's grieving for a version of yourself that might have been. That's what this is about. So I think we commonly find relatively broad support for the idea that there should be criminal consequences, criminal responses to perpetrators of sexual assault and sexual abuse. I hope that we can find comparably broad support today for the idea that there should be civil remedies, which again, I think have more to do with actual healing than the criminal response, not that the criminal response isn't also important. If you were here in the prior debate back in 21, you might have heard the legal questions, hey, does this fit within the public policy exception? There are no legal questions here, because all we do is we invite the people under the referendum power to be the ultimate judge of how the state constitution goes. There's just a judgment question, there's just a values question. Do 24 or maybe more of us come together and send this over to the other chamber where they can grapple with the same questions that we're grappling with here today and ultimately put this to our voters and begin the process of a pathway toward assigning the cost of harm to those who've done the harm and for healing for those who have been injured by these hideous things. Do we simply begin that process?
Senator Watson, would you like to go into your next 10 minutes?
Thank you, Mr. President. As it happens, I'm about done.
Please, go ahead.
That's all we're talking about here, is beginning that process. It's a pretty simple moral question. If you do wrong, should you have to answer for it? I think we all teach our kids that. I hope that enough of us vote yes today. Thanks for listening.
Mr. Minority Leader.
Thank you, Mr. President. Senate Concurrent Resolution 002. I hear the pain-filled stories. I see and regret the agony of the survivors. Senate Republicans unequivocally condemn anyone who commits crimes against children. The acts subject to this resolution are vile, inexcusable, evil, and represent the very worst of humanity. For years, members of the Senate Republican caucus have fought to protect survivors and bring those who harmed them to justice. Our track record has expanded justice with restrictions to the statute of limitations on both criminal charges and civil claims arising out of the sexual abuse of children. We have also expanded mandatory reporter laws. Senate Concurrent Resolution 25002 does not tie perpetrators to their crimes. It upends numerous constitutional and legally settled rights, including principles of legal certainty, the principle of finality of litigation, and other elements of due process. As a matter for my heart, this is a very difficult vote. As a matter of principle and the rule of law, this vote is clear. Thank you, Mr. President.
Very good. Further discussion? Senator Danielson.
Thank you, Mr. President. I probably should have had the resolution read at length. So I think I'll take a piece of it now. This is 3 pages of legislation that includes the technical stuff at the end. But what this bill does is very, very clear. It says that the General Assembly may enact laws that they can't enact right now. Yes, these are evil and inexcusable, unconscionable, unforgivable, in my opinion, acts perpetrated against children. We are talking about people who rape children. We are talking about institutions that cover it up, that shield those perpetrators instead of protecting the children that we put in their trusted care. This legislation does tie perpetrators to the abuses that they inflicted on kids. How? Because right now, we are unable to legislate on behalf of survivors of childhood sexual abuse because of a small provision in the Constitution that prevents retrospective activity. It was made very clear by the Supreme Court because we passed a bill in 2021 that did outline every detail of how survivors of childhood sexual abuse could pursue claims against their abusers if their statute of limitations had run. Victims have been coming here for decades, 40 years now, 40 years, to beg you to do right by them. And we finally did that. In 2021, we finally did that for them. And the measure earned bipartisan support. But it was found unconstitutional, even though we crafted what we felt was a constitutional approach. And so this measure asks the public, because if you reject this policy, and we only need one member of the Republican Party to come on board with this, to push this forward, one person. If you reject this policy today, we will still go to the ballot one way or another, but we are, as my colleague from Aurora pointed out, limited to two ways of getting on the ballot when you want to alter the Constitution of the state of Colorado. One, refer it from this body with a 2/3 majority. Two, go to the public door to door and ask for signatures to place it on the ballot. When the Supreme Court overturned the policy that we passed in 2021, they gave us a path forward. And as soon as that decision came down, I had calls from survivors from all across the state saying, what next? What next? I'm in. I'm all in. These are people who have carried the burden of their abuse through their entire childhood into their entire adulthood. And some of them didn't make it. Like I had to tell you about yesterday when I asked my friend, who has stood with us in these halls for 5 years now, begging you to do the right thing, said, I know what I'd like you to say tomorrow, in addition to my painful history, in addition to my trauma. My twin brother shared it, and he just passed. We did tie the perpetrators to their crime, but it was overturned. We cannot hold these abusers accountable for what they did to our children without changing the Constitution, and this is a very narrow provision that is only specifically pertaining to survivors of childhood sexual abuse. Childhood sexual abuse. Statute of limitations on childhood sexual abuse, when in history was that ever socially acceptable? To sexually abuse a child? I can give you the answer in case you were unclear. It's never. It was never acceptable. Upend due process. Again, SCR 2 only says that in order for the legislature to do their jobs and pass these bills, we need to change the Constitution to allow for it. All that SCR 2 does is say, voters of Colorado, you decide. We put this question in your hands because you have the power to alter the Constitution, to allow us to come back, do our jobs, and legislate on behalf of childhood survivors of sexual abuse. You, the voter, we trust you. This body has the ability to put the question to the voter. And what this policy says is crystal clear and very simple. There is no upending of due process. There is no litigation details. There's no caps. There's no any of that in this policy. As my colleague said twice now, this is a simple, straightforward measure that says, should the voters of the state of Colorado have the opportunity to vote on a bill that says, yes, the legislature should make laws to hold perpetrators of child sexual abuse accountable for that abuse, no matter when it occurred. And we asked the voters last year how they felt about that. Wise thing to do if you're putting something forward that you wish to see on a ballot. And statewide, this measure polled in the high 80s. In some of the more conservative places in the state, 86%, for example, in CD3. Nothing polls at 86%. As you all know, Democrats, independents, and Republicans alike outside of this building demand that we do this. Demand that we do this. Because there aren't any of those details placed in this policy, it is a simple question of, do we continue to say no over and over and over again when these victims come to this building? They were kids when this happened to them. And we have the chance to actually make a difference today, to push this forward, to finally say something meaningful and significant. Yes, we're going to let the voters decide whether or not survivors of childhood sexual abuse have the opportunity to pursue a claim against their abusers and the institutions that covered it up. Yes, we trust the voters. We have that opportunity today. Several survivors came to committee and talked to us about their experience, but they also all had a common thread through their testimony, which was behavior of abusers is about power and taking power away from others. They were clearly serious when they begged us to say, do not silence the voters like my abuser silenced me. Do not continue to take my power away. And my colleague is right. I'm not a survivor. I can't imagine having the strength to come into this building and tell those stories over and over and over again to deaf ears. There isn't a more simple and straightforward course of action here. And it isn't just about the survivors that come, the survivors that have already been through the trauma, that are unable to pursue their justice, are unable to reclaim anything that they've spent healing themselves, unable to move on in their own personal healing. It's not even just about them. What we also heard is that because we're talking about people who are in power, in institutions where we place our kids in the trusted care of adults, when these abusers continue to be allowed to function in our communities without accountability, they stay. They still have access to kids. Teachers, coaches, childcare providers, religious leaders, scout leaders, 4-H club leaders, you name it, they are there. For the simple reason that they have never been held accountable for these abuses. And the institutions that covered it up, you could be very well placing your kids in the care of an institution that has already been through this with someone, and you never knew about it because we can't find it out. Give them their day in court, one of the opponents said. Okay, well, except for that they can't. That's exactly what this is about. Removing the provision in the Constitution that prevents us from doing our jobs and legislating on behalf of these victims. I urge an aye vote on this measure.
Further discussion? Seeing none, members, this concurrent resolution requires 24 votes for passage. The motion is the passage of SCR 25002. Are there any no votes? Senators, Mr. Minority Leader Kirkmeyer, Frizzell, Rich, Pelton B, Simpson, Bright, Carson, Catlin, Pelton R, Liston, Baisley. With a vote of 23 ayes, 12 noes, 0 absent, and 0 excused, SCR 25002 is lost. Majority Leader Rodriguez.
Thank you, Mr. President. I move to lay over House Bill 1004 until tomorrow, Friday, April the 25th.
The motion is to lay over HB 251004 to tomorrow, Friday, April 25th. All those in favor say aye. Opposed, no. The ayes have it, and HB 251004 will be laid over to tomorrow, April 25th. Mr. Schauffele, please read the title of Senate Bill 132.
Senate Bill 132 by Senators Marchman and Gonzalez and Representative Soper and Tutone concerning a spirituous liquor manufacturer's authority to conduct tastings.
Senator Gonzalez.
Thank you, Mr. President. We move Senate Bill 132 on third reading and final passage and ask for an aye vote.
Further discussion? Seeing none, the motion is the passage of Senate Bill 132. Are there any no votes? Senators, Mr. Minority Leader Frizzell, Rich, Doherty, Amabile, Judah, Ball, Snyder, Bridges, Simpson, Liston. With a vote of 24 ayes, 11 noes, 0 absent, 0 excused, Senate Bill 132 is passed. Co-sponsors. Mr. Schaffler, please read the title to House Bill 1207.
House Bill 1207 by Representatives Mabry and Duran and Senators Winter and Exum concerning measures to address barriers to pet ownership in connection with residing in a residential structure.
Senator Winter.
Thank you, Mr. President. We move House Bill 1207 on third reading and final passage.
Further discussion? Seeing none, the motion is the passage of House Bill 1207. Are there any no votes? Senators Rich, Frizzell, Kirkmeyer, Mr. Minority Leader Simpson, Henriksen, Baisley, Liston, Pelton R., Catlin, Carson, Bright, Pelton B. With a vote of 22 ayes, 13 noes, 0 absent, 0 excused, House Bill 1207 is passed. Co-sponsors, Senators Wallace. General orders. Second reading of the bill's consent calendar. Senator Mulliken.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for consideration of general order, second reading of bills, consent calendar.
You've heard the motion. All those in favor say aye. Opposed, no. The motion is adopted. The Senate resolves itself into the Committee of the Whole for consideration of general order, second reading of bills, consent calendar, and Senator Mulliken will take the chair.
Thank you, Mr. President. The committee will come to order. The court rule is relaxed for everyone. Will the clerk please read the title of the bill on general order, second reading of bills, consent calendar?
Senate Bill 298 by Senators Doherty and Lundin and Representative Lindsay and Lukens concerning removing the term homosexuality from the definition of sexual conduct in the Colorado Criminal Code.
Majority Leader Rodriguez. Thank you, Mr. Chair. I move for the passage of the bill on general order, second reading of bill, consent calendar, which is Senate Bill 298, and there are no committee reports.
Is there any discussion on the bill on the consent calendar? The motion before the body is the adoption of the bill on the general order, second reading of bills, consent calendar. All those in favor say aye. All those opposed, no. The ayes have it, and the bill is adopted. Majority Leader Rodriguez.
Thank you, Mr. Chair. I move the committee rise and report.
The motion is for the committee to rise and report. All those in favor say aye. All those opposed, no. The ayes have it, and the committee will rise and report.
Senate will come to order. Senator Mulliken.
Thank you, Mr. President. The committee has had a bill under consideration. Will the clerk please read the report?
April 24, 2025, Mr. President, your committee of the whole begs leave to report has had under consideration the following attached bill, being the second reading thereof, and makes the following recommendations thereon. Senate Bill 298 passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage.
Senator Mulliken.
Thank you, Mr. President. I move the report.
The motion is adoption of the committee of the whole report. Are there any no votes? With a vote of 35 ayes, 0 noes, 0 absent, and 0 excused, committee of the whole report is adopted. Senate Bill 298 passes second reading order and gross place the calendar for third reading and final passage. General orders. Second reading of bills. Senator Mulliken.
Thank you, Mr. President. I move the Senate resolve itself into the committee of the whole for consideration of general order, second reading of bills.
You've heard the motion. All those in favor say aye. Aye. Opposed, no. The ayes have it. The motion is adopted. The Senate will resolve itself in committee of the whole for consideration of general order, second reading of bills. Senator Mulliken will take the chair.
The Senate will come to order. The court rule is relaxed for everyone. Will the clerk please read the title to Senate Bill 88.
Senate Bill 288 by Senator Rodriguez concerning preventing certain disclosures of intimate depictions and in connection therewith creating a cause of action for non-consensual disclosure of an intimate digital depiction and adding and amending related provisions in criminal law.
Majority Leader Rodriguez.
Thank you, Mr. Chair. I move to lay over Senate Bill 288 until tomorrow, April the 25th.
The motion before the body is to lay over Senate Bill 288 to tomorrow, April 25th. All those in favor say aye. All those opposed, no. The ayes have it, and Senate Bill 288 will be laid over till tomorrow. Will the clerk please read the title of the Senate Bill 11?
Senate Bill 11 by Senator Doherty and Representatives Weinberg and Brown concerning the use of artificial intelligence-enabled detection components to mitigate wildfires.
I move
Senator Doherty.
I move Senate Bill 11 and the Finance and Appropriations Report.
To the Finance Committee report.
I need a senatorial 5.
Senatorial 5. We will come back to order. Senator Doherty.
I withdraw the motion moving the finance report.
Thank you, Senator Doherty. For an announcement on Senate Bill 11, there was an error on the calendar. It should not have been the Finance Committee report. It's actually the Transportation and Energy Committee report. Senator Doherty.
I move Senate Bill 11, the Transportation and Energy Committee report, and the Appropriations Committee report.
That is a proper motion to the Transportation and Energy Committee report.
In Transportation and Energy, we adopted amendments restructuring the funding that will occur for this bill, as well as some clarifying amendments on privacy concerns. And I ask for an aye vote, and I also have an amendment to the Transportation and Energy Committee report.
Yeah, let's adopt the Transportation, Energy, and Environment Board. Seeing no further discussion, the motion before the body is the adoption of the Transportation and Energy Committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it, and the Transportation and Energy Committee report is adopted. To the Appropriations Committee report. You can. We don't have a settled question. Okay.
I move amendment.
No. To the Appropriations Committee report. Senator Doherty.
Any comments about
You do it.
Senator Simpson.
Thank you, Mr. Chair. The Appropriations Committee appropriately appropriated funding for the bill, which was none.
Seeing no further discussion, the motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it, and the Appropriations Committee report is adopted. There is an amendment at the desk. There is an amendment at the desk.
Yes, I move amendment L4 to the Transportation and Energy Committee.
One sec, Senator Doherty.
I move amendment.
Senator Doherty, one sec. Will the clerk please read Amendment L4?
Amendment L4, amend the Transportation and Energy Committee report dated March 5th, 2025, page 2, line 4, after privacy insert contains a provision for providing public notice by the vendor.
Senator Simpson.
Thank you, Mr. Chair. I move Amendment L004.
That's a proper motion to the amendment.
Mr. Chair, this amendment is added to further strengthen privacy conditions in the event the detection components, which are an allowable technology in this fund, are used. Simply says the vendor must give public notice if a camera is going up, was heavily stakeholder. We decided not to appropriate amendment to run during appropriations. That's separate.
Seeing no further discussion, the motion before the body is the adoption of Amendment L4. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. Amendment L4 is adopted. To the bill. Senator Simpson.
Thank you, Mr. Chair. This bill has a lot to do with cameras and wildfire management. Was privileged to be part of these conversations for the last 3 years, I think, about trying to figure out a way to introduce new technology in wildfire management and prevention space. And every time a bill has come forward, it's really run into some obstacles, routinely about funding and really trying to get Department of Fire Prevention and Control in a position of support where it's actually a valuable tool and resource to them. Really, the good senator from Arvada's work got DFPC in a good spot and was happy to join her in this conversation and supporting this bill about AI and wildfire cameras. Would appreciate your support.
Senator Kirkmeyer? Senator Liston?
Thank you, Mr. Chairman. I just wanted to rise in support of Senate Bill 11. You know, the old adage, a picture's worth 1,000 words. Well, imagine a camera, video cameras at the appropriate places to monitor potential fires and for fire mitigation. I realize that, it's never easy and that there might be some sort of fiscal note, but, we all want our forests and our wildlands to be wildlife sanctuaries and preserved for future generations. And hopefully there'll be money for this down the road. I know we're in a tight budget, but we've had over the years, many years, we see forest fires that burn 100, 150, 200,000 acres or more. So I just wanted to lend my support. I applaud the sponsors for bringing this bill, and hopefully there'll be good video cameras and other cameras at the appropriate places down the road to protect our forests and wildlife sanctuaries. Thank you, Mr. Chairman.
Senator Kirkmeyer.
Thank you, Mr. Chair. And thank you to the sponsors for bringing this forward. I'm not necessarily opposed to the mechanics of the bill. I will point out, though, that I think it was last year that we gave money to the Department of Public Safety to purchase drones, which sounds a heck of a lot like this program. And I thought that was for emergency management activities as well, but I don't know. But anyways, the reason I'm here is because of the fiscal impact. And I understand, and I appreciate, to some extent, that folks are looking at their fiscal notes and really examining them and trying to make sure that we don't have any general fund impact. That's great. I think everybody understands that we are in a situation where we don't have ongoing general fund, and even though this year was difficult, you know, we kind of ripped off the Band-Aid, as I tell my fellow colleagues at the Joint Budget Committee, because we only sort of ripped off a small Band-Aid this year, and we still have a lot of one-time spending in our budget. We're still in a structural deficit, and next year we're probably going to need a tourniquet to stop the bleeding. So again, I appreciate that we're trying to eliminate general fund impact, but it concerns me that there have been a lot of bills, so it won't be just this bill, but there have been a lot of bills that have been coming through that say, hey, there won't be any general fund impact in the first year because we're going to do this with gifts, grants, and donations. And it kind of seems like we're fudging a bit. When we say, yeah, we really thought there was going to need to be general fund, and just so everybody understands, originally the bill was a public-private partnership, but it drew funds from the unused state-owned real property fund. That's still general fund. The money that goes into that fund are not from fees. So it's still general fund, and that's what originally was planned. And it was supposed to be $6 million over 3 years. That's a huge chunk of change. I mean, I know we have a $18.5 billion general fund ongoing budget. So $6 million, I think to all of us is still a large chunk of change, even though in that kind of budget, people like to call it a rounding error. I still call it a lot of money. So the introduced version of the bill basically was going to pull down $6 million over 3 years. In this, they had an amendment, again, appreciate it, that they're going to go with one-time funding. Should a gift, grant, or donation be identified? That's great. What happens after year 2 or 3? There is no gifts, grants, or donations. We don't have $6 million worth of funds. Then is it the expectation that we're going to have general fund? I mean, I know in the appropriation committees, the chair of the Joint Budget Committee said that he'd be an absolute no on general fund. I'm just going to say I've heard that before. I've heard stuff like that before. In the future, I'll be a no. And then in the future, we're not no's. That's what happened. That's how we got into the structural deficit, because we said, oh, it's one-time funding. And then it turned out it wasn't one-time funding, and we get into a structural deficit because we, quite frankly, were overspending, and we just can't curtail our spending. In this case, we're saying, yeah, it won't be one-time funding. It will be from gifts, grants, or donations. But at some point, I'm thinking it's gonna end up being general fund monies to do this program, new program, in the Department of Fire Safety. Like I said, we've given money to the Department of Public Safety for things that look similar to this, so I'm not sure why they need this or why they can't work from one division to the next division and figure out how to use their resources and use them in the most effective way possible. But with that in mind, I have an amendment, and I will put it at the desk.
There is an amendment at the desk.
I gave this.
Will the clerk please read Amendment L8?
Amendment L8, amend the Transportation and Energy Committee
Senator
report.
Kirkmeyer.
Thank you, Mr. Chair. I move Amendment L008.
That is a proper motion to the amendment. Senator Kirkmeyer.
Thank you, Mr. Chair. What this amendment does is it says this. That's wonderful. It doesn't say that, but it does. This is how I'm going to explain it. It basically says, in my terms, in my verbiage, it says that that's wonderful that you said no general fund impact. But it's not so great that you're saying gifts, grants, and donations, And there's still this expectation that somewhere along the line, that one-time gifts, grants, and donations will turn into ongoing general fund spending. So this amendment actually does say that the section in law, 2.5, subparagraph F, is repealed effective July 1st, 2028, so 3 years out, except that this subsection is not repealed if the department receives at least $2 million in gifts, grants, and donations. Now, they were asking for 6. That's what they said this whole thing was going to cost, $6 million over the course of 3 years, even though in the fiscal note, it's $1 million the first year, $2 million the next year. The original cost was $6 million. Came back and said, we're going to do gifts, grants, and donations, so we don't have any general fund impact, so we should be able to sell through appropriations. I just want everyone to understand, if you are bringing forward a bill where you think you get to push out general fund obligation, and think we're being clever by pushing that out of here and saying, oh, but we're going to do it with gifts, grants, and donations, I want you to know I'm not just going to tag this bill, I will tag every bill that does that. Because it just seems like we're trying to fudge our way through. And I'm telling you, next year, you know, we heard what happened in the House yesterday where they voted no on a bill that basically threw the budget out of balance by about $30 million, because apparently they think funding entrepreneurial cannabis businesses is more important than everything else. So I'm just telling you, we're in a tough situation with the budget. So again, this amendment says, look, you don't receive your at least $2 million of the $6 million, $2 million in gifts, grants, and donations within the next 3 years. It repeals this. It basically repeals this section and repeals this bill. That's the effect of it. But if the department does receive at least $2 million in gifts, grants, and donations in the next 3 years, then you get to move forward. Then they get to keep going and they get to keep doing this program. And I guess they will be able to tell me, like, we told you so. And I would be very happy with that. So that is what this amendment does. And I would ask for an aye vote. I think it's a compromise and a common sense way to approach this and approach funding. And I think it's a straightforward way of us all saying, if we're going to determine that our bills are going to be funded by gifts, grants, and donations, then we need to be assured of that. You know, the other day in committee, on a bill that I was presenting, I was asked the question, are you for sure going to be able to raise those funds? And it's $40 million in the next 2 years. And my answer was yes, because we have firm commitment already to raise that $40 million, like a firm commitment. And if we don't, I'm more than happy with you holding my feet to the fire and saying no. So I'm just telling you, this is just a way, I think it's a common sense compromise, and it's a way to ensure that when y'all say you're going to do gifts, grants, and donations, you truly are, and the Division of Fire Safety is truly going to go out and find gifts, grants, and donations. And it's only 1/3 of what they say this program is going to cost. So I would ask for an aye vote on L008.
Senator Simpson.
Thank you, Mr. Chair. Stand in opposition to L008. There was no attempt to fudge anything in this effort, and in reality, this legislature can't tie future legislators to a commitment. When we solve the budget deficit next year, and potentially there's an opportunity for general fund dollars, would like to leave the window open to be able to advance this technology and support it. Would ask you for a no vote on L008.
Seeing no further discussion, the motion before the body is the adoption of Amendment L8. All those in favor say aye. Aye. All those opposed, no. No. The noes have it, and Amendment L8 is lost. To the bill, seeing no further discussion, Senator Kirkmeyer.
All right, thank you, Mr. Chair.
There is an amendment at the desk. Will the clerk please read Amendment L9?
Amendment L9.
Senator
amended-
Kirkmeyer.
Thank you, Mr. Chair. I move L009.
That is a proper motion to the amendment. Senator Kirkmeyer.
Thank you, Mr. Chair. This amendment says this. And by the way, well, let me just do this first. This amendment says basically, notwithstanding any provision of this subsection to the contrary, the department shall not request, and the General Assembly shall not appropriate any money from the general fund to the fund until the department receives at least $3 million in gifts, grants, and donations. Now, I tried to go with the more easier approach where they only had to get $2 million of their gifts, grants, and donations. So if we're not fudging, then it shouldn't be that hard. It shouldn't have been that difficult. And I just want to say this. I know the good senator from the San Luis Valley said, when we solve the budget problem next year. Oh, that's funny. That is a good one. Wow, when we solve the budget problem next year. Oh my gosh. I have confidence in the JBC as well. It's not so much the other 94 members of the General Assembly.
Okay.
Who has difficulty in
Gavel's
cutting
coming out.
things. But anyways, I just think that has got to be the quote of the day. I just want to say that we're going to solve the budget,
We are
our
on
structural
Senate Bill
deficit
11,
next
Senator
year.
Kirkmeyer. Senate Bill
But
11.
saying that, I'm just going to say I don't know how that's going to happen. I sit on the Joint Budget Committee. It's going to take a couple of years. There are still things going on. And so this just says, look, as soon as you raise $3 million in gifts, grants, and donations, because I didn't say that you specifically were fudging, I said we, as in the royal we. I think there's a lot of we going around that likes to say, I'm going to get rid of my fiscal note. I'm not going to have any general fund in here so I can sell through appropriations. And I'm going to do that by saying, I'm going to get gifts, grants, and donations. I'm just telling you, that tactic doesn't work. And so what I'm saying in this amendment, that it's very clear that we are not on the hook for general fund money until the department receives at least $3 million in gifts, grants, and donations. So I would ask for an aye vote on L009.
Senator Doherty.
Thank you, Mr. Chair. We did run an amendment in appropriations which clarified the bill does not cost the state any money. The original, I will just clarify too, the original fiscal note was based on a public-private partnership, which would have had a cost. That is no longer the intent of the bill. We have made that clear with numerous amendments. There is no one-year funding and no partnership established in the bill. We would urge a no vote on this amendment. Thank you.
Mr. Minority Leader.
Thank you very much. I rise in support of Amendment 9. As we are struggling through our financial problems, our budget problems, trying to set some markers, some guidelines, some guardrails, some thresholds that we need to cross is an important part of how you manage a big problem. The old saw is about how do you eat an elephant. It's one bite at a time. Well, this would be one bite on how we eat our budget problem going forward. Simply says that prove up exactly what you're saying. You're going to do it with gift grants and donations, then just write into the bill that the first $3 million must be gifts, grants, and donations so that you don't roll next year immediately into the request of general fund dollars. It's just a good marker, a good threshold for us to set into the statute to make sure we're going to do what we say we're going to do. I urge your support of 09.
Senator Kirkmeyer.
Thank you, Mr. Chair. So here's what we have, and here's what happened in appropriations. It says, notwithstanding any provision of this subsection, to the contrary, the division shall not enter into a vendor agreement that commits the division to continued funding for a technology purchase through a single gift, grant, or donation. Well, that's great. That's a good start. But it doesn't really get us there. So they get a single gift, grant, or donation, or they get several gifts, grants, or donations. And let's say those gifts, grants, or donations total all together, total $50,000. Let's just say they even total $100 million. or $100,000. Let's just say they total that. Their fiscal note says they need $1 million in the first year, and then 2, and then 3 in the subsequent years. This fiscal note was about $6 million. Originally, they were going to take it from a general funded area called the Unused State-Owned Real Property Fund. That's not a fund that's supported by fees. So this year in the Joint Budget Committee, we carried a bill, and it's coming through, and it's about inactive cash funds. And any inactive cash fund for the last 2 years, we're repealing. So I think it's great. That's wonderful. We put in an amendment that says, yeah, if you can't enter into a vendor agreement that commits the division to continued funding for technology purchase through a single gift grant or donation. So you get a couple, you still don't get to $1 million even in the first year. They go sign a vendor agreement. Where do you think they're coming to? Where are they going to pull that money from? I mean, did they not need $1 million in the first year? Did the Division of Fire Safety not give us the correct information? Do they only need maybe half of that, or a third of that, or 1/10 of that, or 1/20th of that? How much do they really need? Because this amendment doesn't really help that much that occurred in appropriations. I think it says, well, I mean, this is how I would interpret it, or at least how I think they're probably going to interpret it. And by they, I mean the department and the Division of Fire Safety. They're going to say, well, we got a couple of gift grants or donations. It's not really how much we need, but we're going to go ahead and sign a vendor agreement anyways, because we're going to bank on, we're going to pull money from someplace else in the department, or we're going to go get general fund for it. Or we're going to have to come back and say, well, now we have a contract that we have to fulfill, so now you're going to have to give us some money. Because we'll be on the hook for that money. And typically, contracting in the state, at least this is the way it used to work, they do these things called umbrella contracts. They go for 5 years. And if it doesn't say in the contract that it's subject to available appropriation, then we've got an issue. And I don't know if they put that in their contracts. So here's the thing. Again, they said they're going to do this with gifts, grants, and donations. Then they should commit to they're going to do it with gifts, grants, and donations. It shouldn't be, gosh, we're going to keep creating a fund. We're going to have a cash fund sitting there. And if we get one donation, we're going to go sign off on a vendor agreement. And we'll figure out the money later. It shouldn't be that way. So again, this year, JBC has a bill that any inactive cash fund for the last 2 years, and by the way, we have over 1,000 cash funds in this state, 1,000 of them. We have just been going across the tip of the cash funds this year. But any inactive cash fund, we have a bill that says we're going to repeal them if they've been inactive for 2 years. So this amendment, where did I put the amendment? This amendment 9, thank you, says, notwithstanding any provision of this subsection, the department shall not request and the General Assembly shall not appropriate any money from the general fund to the fund until the department receives at least $3 million. At least $3 million, at least half of what they said they needed. Not just one single donation, at least half of what they said they needed before they go enter into an agreement. Then we know for sure that there are a bunch of people out there that want to give a gift, grant, and donation to state government to purchase this fire technology. What is it? An air wing. So to get this technology, and we'll see how many people really want to give, and how many, maybe corporations, I don't know, want to give contributions to them. And before my good friend and senator from the San Luis Valley gets up here and says we can't tell future legislators what to do, that's why we pass laws. That's why we have bills. So we can put this into law, and then there can be another law next year that changes it. So again, we're not going to solve the budget issue this year. We're not going to solve the budget issue probably next year completely. Structural deficits, when you've done year-over-year overspending for the last 4 or 5 years, don't go away in 1 or 2 cycles. So I would ask for an aye vote on L009.
Senator Rich.
Thank you, Mr. Chair, and I rise in support of L009. I do have a question about all of this because we're creating another cash fund within the DFPC, and they have already received an appropriation of $65 million. That's an increase of over $1.5 million from fiscal year 23-24. So I'm wondering about the $10 million of this appropriation already vested, why this bill even has a fiscal note. But if I'm wrong on that, I still support 009. Ask for an aye vote.
Seeing no further discussion, the motion before the body is the adoption of Amendment L009. All those in favor say aye. All those opposed, no. The noes have it. L009 is lost. To the bill, seeing no further discussion, the motion before the body is the passage of Senate Bill 11. All those in favor say aye. All those opposed, no. The ayes have it, and Senate Bill 11 is passed. Will the clerk please read Senate Bill 50?
Senate Bill 50 by Senator Judah, concerning a requirement that a government form that requests disclosure of the race or ethnicity of an individual completing the form include a space to indicate that the individual's race or ethnicity is Middle Eastern, North African, or South Asian.
Senator Judah.
Thank you, Mr. Chair. I move SB 2550 and the committee report.
To the State Veterans and Military Affairs Committee report.
Thank you, Mr. Chair. So we passed an amendment that simply said, if you collect demographic info, not personally identified info, that you comply with the federal government, which applies to the Department of Education and the Department of Safety, because those are the two agencies that do not collect personal identifiable education information, which is how we also defined the forms, and I ask an aye vote on the committee report.
The motion before the body is the adoption of the State Veterans and Military Affairs Committee report. All those in favor say aye. Aye. All those opposed, no. The ayes have it, and the State Veterans and Military Affairs Committee report is adopted. To the bill, Senator Judah.
Thank you, Mr. Chair. Members, SB 50 is a bill simply rooted in a powerful truth that people who share my identity have not traditionally been counted. And this was a big reason for the establishment of the Manasseh Caucus, and this is our first priority bill. Too often, our most impacted communities, whether they're communities of color, immigrants, rural residents, or people living with disabilities, include the people who also hail from the Middle East and North Africa region. SB 50 changes that. It creates a framework for real, meaningful engagement with the communities our heritage is rooted in, especially those who have historically been excluded from the policy-making process. This bill isn't just about seeking agencies to check a box. It's about making people feel like they can actually check their own box. During the last census, I was asked to help engage the Muslim and Arab communities. But I had to explain to folks who were leading the charge that this is putting me in a very difficult position. The Middle East, North Africa was not an option on the census. And if you did identify from the MENA region, your options were either to check white or other. The problem, clearly, is that there are Black Africans who hail from
the MENA region, and asking them to check white felt like they didn't matter. And asking any of us to check other felt like we really weren't being counted at all. And I don't want to see that in Colorado. If we want to build a Colorado that is truly equitable, where every voice matters and every community thrives, then we must start by listing. And SB 50 ensures that we do just that, and I urge your yes vote.
Senator Gonzalez.
Thank you, Mr. Chair. I rise in support of this policy because I do think that being able to ensure that communities have the opportunity to affirm their identity and ethnicity for the purposes of being able to indicate their race or ethnicity as Middle Eastern, North African, or South Asian is incredibly important. Similarly, within the census, Latinos are often asked to figure out what box to check. And increasingly, as Latinos have historically been categorized and racialized as either white or non-white, right? That has been a complicated conversation to have within the Latino community. I welcome this opportunity, this policy that allows those discussions within the Manasa community to take place. And I do think that that this policy is an incredibly important first step forward. Why? Because it will better help educators and public safety officials to better understand, better tailor supports and their approaches moving forward. Thank you so much to the good senator from Aurora for running this incredibly important policy. I ask for an aye vote.
Senator Baisley.
Thank you, Mr. Chairman. I understand the idea of the inclusivity from this bill. However, we would do much better to eliminate all classifications rather than add more. If you have a national perspective, as I do, as others here in the body I'm certain do, having grown up internationally, then you will hear from other nations, hey, I understand that in America, even someone who looks like me can thrive, can be successful, can even become rich. And you go, yeah, why wouldn't you? But that's because in many other nations, there are things like caste systems. A lot of nations, there's a caste attitude about people. This nation was founded on the exact opposite principle. That's why we call it the melting pot and not a salad. We all come together. We are put together in a nation that shows that we are endowed equally by the Creator, the same Creator that we all have, and we should not be categorizing ourselves through these superficial demographics. That's where we get ourselves into trouble. I urge a no vote on this, but rather, let's start eliminating the designations and looking at each other as color and a white Hispanic or a non-white Hispanic and all these other designations that only serve to divide us. We are one nation under God. Let's be indivisible. Thank you, Mr. Chairman.
Seeing no further discussion, the motion before the body is the passage of Senate Bill 50. All those in favor say aye. Aye. All those opposed, no. The ayes have it, and Senate Bill 50 is passed. Will the clerk please read the title of the Senate Bill 64?
Senate Bill 64 by Senators Marchman and Representative Clifford concerning notifying a school when a student has experienced a traumatic event.
Senator Marchman.
Thank you, Mr. Chair. I move Senate Bill 64 and the Education Committee report,
As well as the Appropriations Committee report?
as well as the Appropriations Committee report. Thank you, Mr. Chair.
Thank you, Senator Marchman. To the Education Committee report.
Great. In the Education Committee, we were able to scale this back a little bit. We were able to specify that we would roll this out in rural school districts first, and we were able to push this out. 26-27 would be small rural, 27-28 large rural, 28-29 would be everyone. And that's what we did in education.
Perfect. Seeing no further discussion, the motion before the body is the adoption of the Education Committee report. All those in favor say aye. All those opposed, no. The ayes have it, and the Education Committee report is adopted. To the Appropriations Committee report, Senator Marchman.
Thank you, Mr. Chair. In appropriations, we added an amendment that substantially narrows the fiscal requirement by requiring that this remains is not anonymous. Where this lives in the Safe to Tell code requires anonymity, and that was not our intent here. So this amendment had both fiscal and policy implications. So urge your support of the appropriations report.
Seeing no further discussion, the motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it, and the Appropriations Committee report is adopted. To the bill. Senator Marchman. There is an amendment at the desk. Will the clerk please read Amendment L4?
Amendment L4, amend printed bill page
Senator
2.
Marchman.
And thank you, Mr. Chair. I move L004.
That is a proper motion. To the amendment, Senator Marchman.
Great. In education, we talked at length about the difference between a report of child abuse or neglect versus an incident of. And we didn't want just incidents. We didn't want just reports. We want actual incidents. So this substantially narrows the bill. So ask for your support on this amendment.
Seeing no further discussion, the motion before the body is the adoption of Amendment L4. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. Amendment L4 is adopted. To the bill. Senator Frizzell.
Thank you, Mr. Chair. Members, we talk a lot about protecting our kids here in this building, and this is a really good bill that helps schools, without really necessarily knowing what has happened to the kiddo, treat them a little more carefully. So children who experience trauma, such as exposure to violence, crime, or abuse, they really struggle emotionally and academically. Handle with Care, the concept of Handle with Care, is a new trauma-informed response model developed by the West Virginia Defending Childhood Initiative. And it works to mitigate the negative effects of trauma exposure by increasing awareness and knowledge among key professionals, including law enforcement officers and educators. So this is how it works. Say a law enforcement personnel responds to an incident where children are present, they will be able to leave information behind related to the program. The Department of Public Safety ensures that reports are managed properly, and the only information that's included in the notification to the school is the child's name, age, or date of birth, and the phrase, "Handle with Care." This discreet communication ensures student privacy while alerting school personnel to the need for trauma-informed teaching practices and support. And this ensures that kiddos who have experienced trauma receive the sensitivity and support needed to succeed in school without requiring them to disclose or discuss their experiences.
Senator Marchman.
Thank you, Mr. Chair, and I just want to pick up where my co-prime left off. We did significantly narrow this bill. The Safe to Tell report came out, and more than 28,000 reports of child abuse, bullying, threats, suicide, even fires came out. Safe to Tell is in all of our schools. We already have a situation where Safe to Tell is used for schools to communicate with law enforcement. And what this does is it just allows the law enforcement to work with the schools. It reverses that. So with that, I know we've got some additional friendly amendments coming, and I'm going to pass back.
Senator Frizzell.
And I just wanted to say one thing. You know, one reason why I got on this bill is this is actually happening in the Douglas County School District today, and it's really successful. I had some conversations with the school district, and I also had some conversations with my county sheriff, who are both huge, huge advocates of this program. It helps kids. It has a proven track record. This isn't just some pie in the sky. It's being used in Colorado schools today, and it's just so successful that we think that it should be applied more broadly, similarly to Safe to Tell.
Senator Doherty.
Thank you. I have an amendment, Mr. Chair, and I move Amendment L6.
There, one sec, Senator Doherty. There's an amendment at the desk. Will the clerk please read Amendment L6?
Amendment L6, amend
Senator
printed bill.
Doherty.
I move Amendment L6.
That is a proper motion to the amendment. Senator Doherty.
The definitions here lack inclusion of personal identifying information, and there is a gap. Since the handle with care reports are not anonymous, this clarification is needed so that we can distinguish between the two requirements, and I ask for an aye vote. Thank you.
Is there any further discussion on Amendment L6? Senator Marchman.
Thank you, Mr. Chair, and thank you to the good senator from Dohertyville. I appreciate your attention to data privacy, especially when it comes to minors, and urge your support of this amendment. Thank you.
Seeing no further discussion, you want Senator Amabile?
Oh, not on the
On the amendment, yep. Seeing no further discussion, the motion before the body is the adoption of Amendment L6. All those in favor say aye. Aye. All those opposed, no. The ayes have it. Amendment L6 is adopted. To the bill, Senator Amabile.
Thank you, Mr. Chair. I think maybe this is the first time I've come down to the well to talk about somebody else's bill. And I have no idea whether I'm right or wrong, but the bill strikes me as a little bit dangerous. And I just bring my own life experience to this. When I was a kid, we had kind of a kooky household. And it wasn't cookie cutter. And sometimes the police came. And I would have hated it if the school had been told that I had lived in a bad house or that there was trauma in my house. And if they treated me differently because they had that information, and also that I might not even know that they had been told, I would not have liked that. That would have made my life harder. And potentially, maybe not, I don't know, because I don't know what happens when you're being handled with care. But I do know that everybody's experience is different. And I lived in a loving household. It's just that it wasn't the same as other people's homes. And just as an example, I had a gay uncle, and he came to live with us, and we had a small place. So my gay uncle shared a bed with my mother. And there was nothing weird about it, except for that I think my neighbors might have thought it was weird. Maybe they thought that would be traumatic for me. But it actually wasn't. It was fun. And so the bill either, and I said this to the sponsors, and I say it with all respect, it either maybe doesn't do anything, or there is the possibility that it's a little bit harmful to kids who grow up in non-traditional households.
Senator Marchman.
Thank you, Mr. Chair, and thank you to my good colleague from Boulder. I really appreciate you sharing that, sharing it before, and then sharing it at the well. I want to emphasize that since this has been in place in about 3 different school districts, what it has resulted in is 3,300 students being flagged this way. And what we really rely on is the professionalism of the staff that gets this. So the counselors know what it means to handle with care for Bobby versus maybe for Janie. And so we are just really playing into the strengths of the schools that work with our students. But I just really appreciate you standing up and sharing that. So thank you.
Seeing no further discussion, the motion before the body is the passage of Senate Bill 64. All those in favor say aye. Aye. All those opposed, no. The ayes have it, and Senate Bill 64 is passed. Will the clerk please read the title of the Senate Bill 292?
Senate Bill 292 by Senators Amabile and Bridges and Representatives Sirota and Taggart concerning the creation of the Workforce Capacity Center.
Senator Bridges.
Thank you, Mr. Chair. I move Senate Bill 292.
To the bill, Senator Bridges. Or
Great
Senator
bill,
Amabile.
vote yes.
Senator Amabile.
Senator Amabile.
I'll just say this was at the urging of Healthcare Policy and Finance, and it was in response to making sure that we have the workforce in place to take care of kids who have high needs and need high fidelity wraparound services. And this was also part of the lawsuit that was brought against TICPUF because we do not have these services. And so I urge a yes vote.
Seeing no further discussion, the motion before the body is the passage of Senate Bill 292. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it, and Senate Bill 292 is passed. Will the clerk please read the title of the Senate Bill 295?
Senate Bill 295 by Senators Amabile and Bridges and Representatives Byrd and Sirota concerning transferring money received through the firearms and ammunition excise tax into the mental and behavioral health excise tax cash fund, and in connection therewith making and reducing an appropriation.
Senator Bridges.
Thank you, Mr. Chair. I move Senate Bill 295.
That is a proper motion to the bill.
Ask for an aye vote.
Seeing no further discussion, the motion before the body is the passage of Senate Bill 295. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. Senate Bill 295 is passed. Will the clerk please read the title to House Bill 1017?
House Bill 1017 by Representatives Clifford and Froelich and Senator Michelson Janae concerning a community integration plan for individuals with disabilities and in connection therewith making an appropriation.
Senator Amabile.
Thank you, Mr. Chair. I move House Bill 1017 and the committee reports, if there are
There's no
any.
committee reports to the bill.
Okay.
There is an amendment at the desk. Will the clerk please read the title to Amendment L7?
Amendment L7, amending gross
Senator
bill.
Michelson Janae.
Thank you, Mr. Chair. This amendment has some very significant negotiating.
Senator Michelson Janae, do you want to move the amendment for me?
I do want to move the amendment, as a matter of fact. I move Amendment L007 to House Bill 1017.
That is a proper motion to the amendment. Senator Michelson Janae.
This amendment is very significant negotiations with the first floor to make this a bill that would be signable, and I urge your aye vote.
Seeing no.
And this was handed out 2 days ago to everybody on your desks, this one.
Seeing no further discussion. Would you like to speak? Yeah, Senator Simpson.
Move out of the way.
I'm not in opposition.
Yeah.
Thank you, Mr. Chair. I'm just clarification about private right of action. It like in one paragraph, it talks about Olmsted decision, and I'm on the back page. Sorry, federal law under Olmsted currently provides a private right of action to enforce the law. Therefore, the General Assembly does not see a need to create a new right of action. However, if the Olmsted protections are weakened, we urge a future General Assembly to strengthen these rights by creating a private right of action to further enforce this law. And then I think, that's in the legislative declaration. Yeah, and then in statute, nothing in this Part 11 creates a new right of action against the state of Colorado or other public entities. So I think it says basically let the federal government, or under that rule, proceed as normal. We don't require a private right of action unless something changes. So just seeking clarity.
Senator Michelson Janae.
You are clear.
Thank you. Now, seeing no further discussion, the motion before the body is the passage or adoption of Amendment L7. All those in favor say aye. All those opposed, no. The ayes have it. Amendment L7 is adopted. To the bill. There is an amendment at the desk. Will the clerk please read Amendment L9?
Amendment L9.
Senator
amend-
Michael St. John.
Thank you, Mr. Chair. This amendment was requested by a member of the Joint Budget Committee
Senator Michael
to...
St. John, you wanna-
Yes, I would like to move L009 to House Bill 1017.
Perfect. Thank you, Senator Michael St. John. To the amendment.
So this amendment was requested by a member of the Joint Budget Committee to make sure that the money that is set aside to do this work is the actual money used, and it shall not fall on the General Assembly, on the general fund, sorry.
Seeing no further discussion, the motion before the body is the adoption of Amendment L9. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. Amendment L9 is adopted. To the bill. Senator Mobley.
Thank you, Mr. Chair. So House Bill 1017 is going to codify in state law what is arguably the most important Supreme Court decision regarding people with disabilities. Olmstead versus LC recognized that people with disabilities have the right to be free from unwarranted segregation and to be able to obtain the benefits of living in community when appropriate. And those are nice sounding words, but the impact has been far reaching. So I just mentioned a minute ago a lawsuit that the state is under regarding a system of care for our youth. And that lawsuit came under Olmstead. And it says you can't keep a kid in a hospital setting if the kid actually should be in a lower level of care. You can't keep a kid in a detention center if the kid should be in a lower level of care, a less restrictive setting. But the other thing that's near and dear to me is that you can't keep somebody with serious mental illness in a jail cell if that is not the appropriate level of care. And that is something that we are doing here in Colorado. But we are under a consent decree because we were sued, because what we were doing was unconstitutional under Olmstead. And so now we are putting resources towards getting people out of jail and into a hospital setting or an outpatient setting or whatever it is that's more appropriate for them. And that's why this lawsuit matters so much and why codifying this in state law matters so much. And I urge a yes vote.
Seeing no further discussion, the motion before the body is the passage of House Bill 1017. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it, and House Bill 1017 is passed. Will the clerk please read the title of the House Bill 1209?
House Bill 1209 by Representatives Lindstedt and Wilford and Senator Gonzalez concerning measures to address efficiency in the regulation of marijuana licensees and in connection therewith reducing an appropriation.
Senator Gonzalez.
Thank you, Mr. Chair. I move House Bill 1209 along with the Finance and Appropriations Committee reports.
That's a proper motion to the Finance Committee report.
Thank
Senator
you,
Gonzalez.
Mr. Chair. During the Finance Committee, the committee adopted a number of amendments to bring, to address stakeholder concerns, brought Blue Rising to neutral, and also worked to clarify and streamline the process. I ask for an aye vote.
To the Finance Committee report. Is there any further discussion? Seeing none, the motion before the body is the adoption of the Finance Committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it, and the Finance Committee report is adopted. To the Appropriations Committee report, Senator Gonzalez.
Thank you, Mr. Chair. We adopted the correct appropriation in the Appropriations Committee, and I ask for an aye vote.
The motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have the Appropriations Committee report is adopted. To the bill. Senator Gonzalez.
Thank you, Mr. Chair. I move House Bill 1209 on second reading and ask for your support of this policy, because I think particularly given the actions that took place in the lower chamber yesterday, we all understand and recognize that this industry is really important and critical to us being able to balance our budget, A. B, what we have seen, having been the first in the country to legalize cannabis, was that we kind of went way overboard, if I'm being really honest and candid, in the ways in which we set up the regulatory infrastructure. Now that we have seen other states come online, they have learned from our example and actually set up different mechanisms for enforcement that both advance safety while also ensuring efficiency. And yet, here in Colorado, we have been working slowly to address those regulatory challenges and hurdles. But I think particularly post 2021, the industry itself has experienced a really severe economic downturn, and which has impacted our state budget by due to the dramatic reductions in the tax revenue collected into the MCTF. MTCF, I apologize. And so what 1209 seeks to do is to ensure that the regulators actually are focused on that which is most important: accountability and safety. Not counting the number of cameras that might be in a closed room. That's not helpful, but actually ensuring that there is clear requirements for safety. That's what really matters. And I'm proud to have worked intentionally alongside proponents, opponents, and everyone in between. I'm proud to have worked alongside the Majority Leader on this policy. I ask for an aye vote.
Mr. Majority Leader.
Thank you, colleagues. I rise in support of this bill. We don't need to regulate marijuana, as my colleague from Denver said, that like when we passed this law on the first in the nation in 2012. The industry has changed. It is not the sole market, and the businesses are more struggling with the way that the industry has changed, with multiple states having this. And this bill is just trying to align and get rid of some burdensome, not necessarily regulations, while giving the Marijuana Enforcement Division more time to actually work on the enforcement and the parts that we care about. Simple things that it's trying to do is removing duplicative fingerprinting for non-owners, replacing it with name-based checks, which are quicker and still flag serious offenses, eliminates the need for every single employee to wear a state-issued badge, which does nothing to increase safety but just adds cost and bureaucracy, and clarifies rules about business transactions, research and development, and internal operations so Colorado companies can stay competitive in a tight national market. Colorado was the first state to legalize this, and we went on an excessive side of caution. We're just trying to catch up the industry to things that have been tweaked since it's happened, to make it easier for businesses to not just overly whelm themselves with bureaucracy and red tape and extreme regulations. Ask for an aye vote.
Senator Amabile.
Thank you, Mr. Chair. So I'm now 2 times in one day. Sorry, you guys are going to be sick of me by the end of today. Today I got time. I guess I just want to say there are thousands of families in Colorado who have been negatively impacted by their loved ones' marijuana use. And for some reason, this body thinks that this industry is somehow better than other industries that also have negative externalities. And so the oil and gas industry, we want to regulate that because it has negative externalities, because we think it's hurting people's health, because we think it's hurting the planet's health. The tobacco industry, we think we should regulate that heavily because tobacco is harmful to people's health. And we are charged with regulating industries in order to make sure that we do everything we can to stop them from hurting people. But we have turned a little bit of a blind eye towards the marijuana industry. And yes, the tax dollars do fund a lot of things, as do taxes from alcohol, as do taxes from oil and gas, severance tax. I mean, our state would be lost without this money. So I don't know why we think this industry should be deregulated, when in fact there is mounting evidence every day that the harms that are caused by marijuana use are real, they are significant, and they are costing our state a lot of money, and they are costing individual human beings in our state to suffer. And so I want to see us regulate this industry more, not less. One of the really big things that is emerging as a result of marijuana use is psychological diseases, like my son's disease, which every psychiatrist we went to said that at least one of the factors in him developing schizoaffective disorder was his early and persistent marijuana use. And he is absolutely addicted to marijuana. He cannot stop using it. And I am in groups with parents who have this exact same problem. And I think a lot of you saw the Mad Moms who were here. All of their kids have mental health disorders. And one thing they all have in common, well, many things actually, they all use marijuana. And they all used marijuana when they were kids. And so, yes, like the tobacco industry used to say, well, not everybody who smokes cigarettes gets cancer, so they must not even be related. And then we found out that's not true. So it's personal for me. I will be a no on the bill, but I do appreciate the sponsors working hard to get some of the advocacy organizations to a neutral position. Thanks.
Senator Simpson.
Thank you, Mr. Chair. Thank you to the sponsors and folks that are passionate about this conversation. I heard it in Finance Committee a week or two ago and was really conflicted to go. I appreciate the opportunity to deregulate an industry to some degree, lessen some of the burden. Heaven knows we've regulated people more and more in this state the 4 years I've been here. So the opportunity to rein in some of that regulation was appealing. I really think about it in terms of where that reduction in regulation originated and came from. It came from the industry. The industry identified these are areas that would help us be more efficient and more profitable, and then a carry-on effect is, all right, now MED also can now focus on more important areas. Even in Committee on Finance in the second chamber, we were offering amendments brought forward by MED to get them in a comfortable position. I think had this reduction in regulation and oversight been a more concerted effort between the industry and those overseeing the regulation, I probably would have had a better appetite for supporting the bill as drafted. It just feels, again, a little conflicted about how those items are identified that would help the industry be more successful and more profitable. I'd love to do the same thing with any number of industries, thinking of landlords in particular, thinking of farmers. There's lots of opportunity where the state can focus on reducing regulation in our state so we can move away from being the 6th most regulated state in the union to more towards the bottom. that was my thought process about voting against 1209 in Finance Committee this week. But I do appreciate working with the sponsors and the advocates in the lobby and help educate me. This is not a space I'm actively involved in. So I've never been in one of the recreational outlets. I've been in a grow operation one time, got invited to go tour a grow operation. It just made me jealous. They were more profitable on a half acre than I am on 800 acres. So appreciate again the opportunity to come up and express my concerns about 1209. Thank you, Mr. Chair.
Senator Bright.
Thank you, Mr. Chair. I also heard this in Finance Committee a couple weeks ago, and if you look at the records, you might see that I had a no vote on this. And I deliberated on this for quite some time, and I can tell you what it came down to for me. I subscribe to the viewpoint that regulations exist in general for a general level of public safety. If we need to create a safety level, a general safety level for the public, then we create a regulation to protect those folks. If we have exceeded a basic level of safety, then that is what I would define as over-regulation. And so I subscribe to bringing those regulations down because it just does nothing but drive up the cost of products and turn away business within Colorado. As you might know, I work in the preschool world, and I see kids 3 and 4 years old coming in with copious amounts of marijuana in their backpacks. I'm not saying they put it there. I'm saying their parents probably did for whatever reason, and that's just not safe. I don't feel like we've achieved a general level of public safety with the regulations that exist. In general, I would definitely be a proponent of reducing regulations, but when we still have those challenging issues of preschoolers bringing marijuana in their backpacks to preschool, I feel like we just haven't reached it yet. And so I feel like we really need to take a look at the regulations that exist inside of this industry and make sure they're appropriate to create that general level of safety for our society. So that's why I was a no vote in committee. I'll be a no vote on this bill as well.
Seeing no further discussion, the motion before the body is the passage of House Bill 1209. All those in favor say aye. Aye. All those opposed, no. The ayes have it, and House Bill 1209 is passed. Will the clerk please read the title of House Bill 1239?
House Bill 1239 by Representatives Zakai and Basnicker and Senators Doherty and Weissman concerning modification of the remedy provisions in the Colorado Anti-Discrimination Act and in connection therewith reorganizing and expanding the provisions for damages in a civil action for certain discriminatory or unfair practices and making an appropriation.
Senator Weissman.
Thank you, Mr. Chair. We move 1239 and the Judiciary Committee report.
To the Judiciary Committee report.
In Judiciary, we cleaned up an error in a part of the disability statute.
Senator Weissman, 1 sec. Members, we are on seconds. Can we please focus on the well? If you have to talk, take it off the floor. Senator Weissman.
Thanks, Mr. Chair. The Judiciary Committee report reflects one amendment fixing a drafting error in a part of the disability statute on testing accommodations. We ask for your support.
Seeing no further discussion, the motion before the body is the adoption of the Judiciary Committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it, and the Judiciary Committee report is adopted. Senator Weissman, to the bill.
Thank you. Members, 1239 is some updates to CADA, the Colorado Anti-Discrimination Act, which is the law by which we make sure that folks in protected classes are not treated unfairly or have remedies if they do. In 2022, the Supreme Court handed down a case that made a pretty big change in how remedies could be sought under federal law, Section 504 of the Rehabilitation Act that had been longstanding federal statutory law. The case was Cummings v. Premier Rehab, if anybody wants to look it up. We are just seeking to restore the status quo ante with respect to that case to make sure that there are remedies in state law should folks with disabilities experience discriminatory conduct in places of public accommodation. There are caps on the non-economic damages that can be sought. There are sort of softening remedy provisions whereby good faith attempts to remedy the problematic conduct may be sort of rewarded, if you will, by a reduction in damages otherwise owing. We make some conforming changes in other parts of the COTA statute. We also clarify longstanding provisions on provisions about discriminatory advertising in COTA, since those sections had been neglected. Members, a former colleague of ours, Representative Ortiz, used to remind us that unlike most other protected classes, disability status, frankly, is something that could happen to any of us tomorrow. So I hope that we would all be mindful of that, mindful of the challenges that folks living with disabilities, visible and invisible, face, and that we would be willing to be favorable to this legislation, which was pretty heavily amended, negotiated, and even compromised in the House. But as it looks like there's going to be some discussion, notwithstanding all of that, I will step back for now.
Senator Doherty.
Yes, I believe you had an excellent description of the bill already, so I'll just say we think this is very important as federal civil rights laws are being weakened across the board, and we would urge an aye vote.
Senator Kirkmeyer.
Thank you, Mr. Chair. So, members, I have some questions here. One's about the fiscal note, but also just kind of about the general applicability of this new law with regard to intensive behavioral health facilities that are serving individuals with disabilities and that the state pays for, which, so that would be a public accommodation. I want to know also, if you wouldn't mind, good Senator from Aurora, to explain, or from Arvada, explain how this would impact Section 8 housing, Fort Lyons, our mental health hospital, and Ridgeview, which is a now state-owned homeless shelter, essentially, out near Watkins, Colorado. Because I'm concerned, I didn't see anything in here, but I was trying to listen to what you were saying. I'm concerned, are we going to end up with, in this bill, there is now a statutory fine of $5,000 payable to each plaintiff for each violation. Is that something that the state should be accounting for at some point possibly, or that we should be thinking about? There's also the damages for non-economic loss or injury. But I'm just going to point out that over the course of the last few years, but even just in the last 2.5 years, the Healthcare Policy and Finance just finally agreed on a settlement agreement that involved these intensive behavioral health services. And apparently the way that the individuals with disabilities were being treated was not in coordination with the way they should have been, and with dollars spent from Medicaid and other services. And it ends up, we're in a settlement, trying to get it fixed, but it's costing a lot of money. And I'm not saying we shouldn't be getting it fixed. I'm just saying it's costing a lot of money. And I don't know if this adds on to it. So that's my question with regard to healthcare policy and finance. But then, we have Section 8 housing that is public housing that receives public funding. So are we on the hook there for additional, for these violations? And again, the Fort Lyons Mental Health Hospital, and then the new facility that should be opening up, I don't know, sometime soon. It was supposed to open up, I thought, this year, but may not be till next year. But that new facility, Ridgeview, which is essentially the state will be operating a homeless shelter, but people will be staying there for extended lengths of time. I don't think it's just, a one-day kind of thing. I just want to know how this will impact that. And then my other question, or I could stop there if you wouldn't mind answering. I'll stop there.
Senator Weissman.
All right, thank you. I'll try to start taking a run at that. Threshold comment, the Americans with Disabilities Act went into law in 1990. So here we are, it's 35 years old. Governments are familiar with the responsibilities. Businesses are familiar with the responsibilities. Again, channeling a little bit of our former House colleague, we're not talking about anything new here. We're in part trying to give effect to what the law has long been. Now, as to the fiscal note, when we do a bill like this, and you know, we were actually talking earlier this morning about the question of civil remedies for other sorts of things. Similar architecture of such a fiscal note. I'm going back to the one in 2021. Anyway, the reason that we have a modest note here is to account for the possibility that the state may be among those who are found by a court to have done wrong to folks with persons living with disabilities. So see bottom of page 3 into page 4 in terms of how the fiscal analysis goes for that. There is a low capped monetary amount called out in statute. That's the $5,000 figure. There's a cap on non-economic damages. I used the term earlier this morning, pain and suffering. And then, you know, there's an attempt in the fiscal analysis to speak to how attorney fees go. I think when we see a note for a bill like this, the nonpartisan staff will engage with the risk analysis unit of DPA. They'll get the data that they can. They'll look back, try to map what we're doing in current policy onto that. That's how we come up with the analysis. Ultimately, the better a job the state does in terms of respecting the rights of folks with disabilities to not experience discrimination in places of public accommodation, the lower is the liability to the state. What I think the note reflects overall is the state is basically expected to stay within bounds, and we don't have, I don't think, very big numbers, not to make light of the fiscal climate that we are in. So that's my attempt to respond generally to the questions about how the note goes on this bill. As to the specific facilities, I'm certainly familiar with Ridgeview and the repurposing of it. That facility is out in my corner of the world. But as to the other facilities named, those did not come up in any way in the committee discussion. So I don't have specifics to add about what the risk profile would be for any particular state facility. But again, the note just tries to state generally what exposure to the state might be if conduct is not within the bounds of the law in the first instance. I hope that's helpful.
Senator Kirkmeyer.
Thank you, Mr. Chair. And I appreciate that, and that is actually why I have a concern. So the fiscal note itself just basically speaks to assumptions with regard to how many additional lawsuits there would be, and it does not speak to any dollar amount or the impact, potential impact of the civil penalties. That's the concern. So just even the additional lawsuits, 10 additional lawsuits in the first year, 20 additional lawsuits in future years, on top of the 20 public accommodation lawsuits that have been brought against the state in the past 8 years. So that's where they garnered that from. But they're saying there could be an additional 10 lawsuits. Members, we have lawsuits right now that are going on. We've had one that just got settled. There are other lawsuits that are going on. This fiscal note just speaks to, from what I can figure out, what they believe to be the cost to defend the lawsuits, because it's money that will be reappropriated funds, and even some of those funds will be probably general funds. So if you look at the fiscal note budget year, the first year they say it's $369,000, and then it talks about FTE, but that's just to defend the lawsuits. And then it goes on to say that in the next years it'll be like 1.5 and 2.1 in 26, 27, and 27, 28 respectively, from reappropriated funds. Reappropriated funds come from cash funds. That may have originally been some general funds in there, but they come from cash funds, and they also comes from federal funds. So we would be taking money from, especially if it's coming from federal funds, that would go to defend the lawsuit versus the program they were intended to go to. That's one issue. But the other issue is there's nothing in here that says, here's what the civil penalties may be, the impact on the state's budget in that way. Or more importantly, especially with the situation with Ridgeview, which is a state-run, which will become a state-run homeless shelter, transition shelter. I'm not sure exactly what they're calling it, but it's for homeless people. If you remember, this went through a couple of years ago, and it's to help transition them, help transition people who are homeless into helping them getting jobs, wraparound services, and also finding affordable housing. So, but that is state-owned. It is a public accommodation, and I don't know how many people it's supposed to be, but it's more than just a couple. I mean, I could go probably find out, but I know that could be a lot. And the fines in here are $5,000 payable to each plaintiff for each violation. That could start adding up. $50,000 for recovery of damages, up to, well, not to exceed $50,000 that they could get. And I understand there's a cap. And this bill also doesn't speak to, again, I'm a little concerned about all the Section 8 housing that is funded both through the Department of Local Affairs and the Department of Human Services. And I don't know if that's included in here as well, if the state could be on the hook for some of that, if it means that some of the Section 8 housing dollars that are meant to help people find affordable housing, people who meet certain eligibility criteria with regard to income, then are we on the hook for that? So instead of funds going towards funding, apartments or housing units for people with low income, is it going to basically pay for fines and an amount not to exceed in damages for non-economic loss? I just don't know. But I am telling you, my greatest concern would be the intensive behavioral health facilities that are under our jurisdiction and that our liability, and the Fort Lyons Mental Health Facility, which we have a lawsuit going there, that we are spending millions of dollars to try and rectify and come into compliance. If this adds on to it, I'd be greatly concerned about that. And then with Ridgeville, I would be greatly concerned about that. And the fiscal note, again, only talks to the amount of money that it is needed to defend a lawsuit, that they anticipate to be an additional 10 lawsuits in 1 year, and then an additional 20 lawsuits in the next year. I'm not sure why the Attorney General's office is saying that, but that's what their numbers are. And this fiscal note does not reflect anything about how much this could end up costing the state should they fail on those lawsuits. So it's just a concern that I have. I can appreciate what's trying to be accomplished here in this bill, but I think it could, it could end up impacting especially Ridgeview, where basically we end up having to shut down that facility because we can't afford to pay the fines and can't afford to pay the damages, which would be very sad if that's happening there. But given the fact that the Attorney General thinks that there could be, or the Attorney General's office, I'm assuming that's who put that in the fiscal note, assumes there could be an additional 10 lawsuits and 20 lawsuits in future years. So 10 in the first year, and then they think it's going to double after that. And I mean, once it gets going, it could just really get going. Is the reason why I would ask for a no vote on this bill.
Senator Carson. Senator Weissman.
Yeah, thanks. I just wanted to respond a little bit to the last line of discussion. Members, the limitations on how recovery goes, regardless of who the defendant is, are on page 4. One who is successful, a person with disabilities in an action, is entitled to recovery of actual monetary damages. As a reminder, the burden is on plaintiff to establish that by a preponderance, and then either non-economic loss or injury damages, we cite to a commonly used part of statute to flesh that out, capped at $50,000, again, subject to further reduction in the case of demonstrated good faith, or a statutory fine, $5,000. Rough analogy, you could think about that as liquidated damages if one is familiar with that phrase. So if we project that onto the state, what do we get? I'm going from page 4 of the fiscal note dated March 25. Again, when we get into these questions of compensation owing to injured people by the state, we're in the world of DPA and their risk management function. I'll read a little bit from the note. The Risk Management Fund maintains a reserve that is comprised of payments made by state agencies for legal services and risk management through common policy. Billings based on costs incurred in prior years. Skip down. The note expects 3 additional public accommodations discrimination lawsuits annually based on these estimated cost and above factors. It's assumed costs under the bill can be paid from the Risk Management Fund, and no immediate change in appropriation is required. Again, I think the state of Colorado generally strives to respect the rights of folks with disabilities when it comes to public accommodation. Frankly, it would be really problematic if we were to see a note with large numbers, because that would be indicative of behavior I don't think any of us would want to condone as policymakers. Fortunately, we're not seeing that. I will also note, we all know, regardless of our party, regardless of our policy area, what it is when representatives of the administration come to us and talk about our policy. We just heard a colleague do an amendment on a different bill for that kind of reason. We haven't had those discussions as sponsors. Those concerns haven't been brought to us. So I hope that helps clarify a little bit.
Senator Kirkmeyer.
Thank you, Mr. Chair. And I appreciate those comments. Thank you to the good senator from Aurora. Appreciate your comments. I would just note that the state governments that were contacted was judicial, law, personnel, and regulatory agencies. It was not healthcare policy and finance. It was not the Department of Local Affairs, and it was not the Department of Human Services. And the reason I mentioned those three departments, because those are the three departments that are putting dollars and have programs that provide public accommodation to individuals with disabilities. And in all cases, it's not necessarily intense disabilities, but it could be, like I said, the Department of Local Affairs has an outside contractor now, a vendor, who I think they've got them hired, but I'm not exactly sure, who will be running and managing a homeless transitional type facility out near Watkins. And it's costed us a lot of money to bring it up to code, which we should appropriately if we're going to manage things. Wasn't something I supported or voted for, because I don't think government should be managing or running those types of things. But anyways, they were not consulted in this, so I don't know if this is going to impact them or not. But I do know that the fiscal note only speaks to the legal defense of a lawsuit. It does not speak to anything with regard to what the penalty could be should they be found in violation. And with regard to those facilities that Healthcare Policy and Finance operates, or the Department of Human Services operates, which would be our Fort Lyons mental facility, and then there's these intensive behavioral health facilities. It's not necessarily the individual that is listed here that we talk about in the bill, that talks about individuals, the inability of individuals with disabilities to recover damages. I mean, I appreciate that. But in the cases that I'm talking about, it is groups like Disability Law Colorado and Protection and Advocacy System for Colorado that have well-meaning folks, and they're looking out for these individuals that are in our systems, and they should be. Thank you. I mean, it's sad, but yes, you should be. And these are people like, for example, one of the folks who is the executive director of these groups used to be the Speaker of the House, so they know. But again, in this fiscal note, this was not considered because we did not ask these departments. And as I'm reading through the bill, it appears to me, again, I am not an attorney. I appreciate the comments that are coming from the good senator of Aurora, but it does appear to me that the only thing in the fiscal note that was considered was how we're going to defend the lawsuits and not the result of those lawsuits. And I'm telling you, the lawsuits that we have already had, if this adds on to them, it would just add on more hundreds of millions of dollars. We were told with one of the lawsuits that we have that we could expect that it could cost anywhere from $300 to $400 million to settle the lawsuit as we move this forward in the next coming years. So that wasn't all in 1 year. That wasn't just this. That wasn't this year. But this year alone, we had to move around millions of dollars. In fact, we moved around about $10 million to start working on the settlement, and that's just the beginning. That is just to start getting us, to get that workforce capacity center bill that you just heard about, to do things of that nature, to start providing some services. There's all sorts of concerns, but these things cost a lot of money. Not saying we shouldn't be doing what's right by individuals with disabilities. That is not where I'm going. I'm just saying it appears this legislation would add on to that, and I'm deeply concerned about it, and that's why I would ask for a no vote on this bill.
Senator Carson. Thank you, Mr. Chairman.
I appreciate the comments of the senator from Brighton on the costs that this bill will impose on the state government, certainly ultimately on the taxpayers. I think we've underestimated a lot of those costs here in the fiscal note. But I'd like to shift the discussion a little bit to the costs of this bill on small business, on business in general. And my concern with this bill is that we're blazing a new path here, and I'm not sure we want to set this precedent. Basically, if you're a small business person here, you get no warning. Basically, the suit is filed, can be filed, and the penalties imposed, $5,000, which to a small business is not a small amount of money, and then up to $50,000 in additional damages. Now, you can get the curious thing here is you can get a 50% reduction in the penalties, but that's even if you comply. So the way this, there's a tiered system here is if you, if you comply within the first 30 days, you can get a 50% reduction in the penalty. Now you can get additional 30-day increments here, although again, and that can go up to 120 days. But it's not clear entirely to me who determines all that. It says a defendant that is not able to fully comply to correct a violation within the 30-day period set forth initially here may be allowed additional time in 30-day increments, not to exceed a total of 120 days. Now, it talks about the defendant showing a good faith effort to correct the violation, but how is that determined? If the defendant has not fully corrected the violation within 120 days, the defendant is not entitled to that 50% reduction. But again, it's not clear how it's going to be determined whether a good faith effort has been made by the small business to comply with this. And I think this is really contrary, this framework is really contrary to the way we want to deal with small businesses and give them an additional period, a warning to comply, rather than immediately going into this process of fining folks. And so with that, I am going to offer an amendment here.
There is an amendment at the desk. Will the clerk please read Amendment L16?
Amendment L16, amend re-engross bill, page 3, line 27, strike A, and substitute if a person fails
Senator
to cure.
Carson.
Thank you, Mr. Chairman. I move Amendment 016.
That is a proper motion to the amendment, Senator Carson.
So, Mr. Chairman and members, this amendment basically states that an aggrieved individual, one bringing the complaint, can only sue after there's been a clear failure to cure the alleged violation. So basically, you got to get some indication from the business or the governmental body, because as my colleague from Brighton spelled out, this is going to be a big issue for the state of Colorado, because we do have a lot of buildings that are likely going to have to be upgraded, and we're going to have a lot of litigation costs around that. But what this amendment basically says, you got to have kind of a first step before the lawsuit can be filed. And if the business, I've primarily been talking about small businesses, if the small business says flat out, we're not going to comply, okay, then we move forward in this process. But if there's an indication that there's going to be compliance, then the lawsuit could not be filed. So I think, that's a better framework, the way we want to The ultimate goal here, of course, is to get more protections for disabled individuals, more access. But let's make it more of a cooperative process here where, you know, if you've got a small business that says flat out, hey, we're not going to comply with this, well, that seems to me to be a very different matter than one that's trying to comply under the framework here. And you know, you still have the issue here with, if you go forward with the litigation, you only get a 50% reduction even if you work to comply with it. So my concern is there are entities that go around and shop this kind of litigation. They go out and they look for violations, and I don't think that's a fair approach to small businesses. A lot of times these violations are inadvertent. They're attempting to be more accommodating to the public, but it's expensive and difficult at times. And then to bring in these additional penalties, and even when you try to correct things, you're only getting a 50% reduction. So I'm going to urge support for this amendment, L016, which basically says, you know, you got to have that first step, a refusal to comply.
Senator Weissman.
Thanks, Mr. Chair. Members, we're going to ask for a no vote here. You know, we've already negotiated a fair bit in the way of caps and you know, the reductions in damages for good faith. I think the fundamental problem with this amendment is, frankly, the experience of folks in the disability community for many decades, which is being treated as some kind of second class or in some kind of second class way. Civil rights laws are pretty fundamental in our state, in our country, even if they're under attack at the federal level. We set forth rights. We do, frankly, have remedy provisions there, in part to keep the wrong thing from happening in the first place. Again, we're just trying to go back to status quo ante before the 2022 case that we talked about. We've, in some respects, even softened it beyond that. I don't think that folks with disabilities deserve any less in the way of a remedy or degree of protection in our law than other folks of different protected classes or statuses in other parts of CADA. So I think a no vote is appropriate here.
Senator Carson.
Yeah, so I think it would be a better approach if we just have a more cooperative process here. We give the businesses a chance to show a good faith effort to comply, and so I think this amendment is a good addition to the bill. And I'd like to call for do we have some more comments? Go ahead.
Senator Kirkmeyer.
Thank you, Mr. Chair. I rise in support of L016. Again, an individual or the state or a local housing authority. I want you to start thinking about how far this could go. Or a local housing authority fails to cure the alleged violation. Then they could get sued. That's what we're asking here in this amendment. I mean, as I started thinking about this and talking with more folks, just went out and spoke with the Attorney General's office folks as well. I'm like, you know, and the local governments weren't contacted either. So it doesn't look like affordable housing folks. You know, we have these housing authorities. Doesn't look like they were contacted here either. I mean, I don't know. I'm just telling you. It's one thing when, I mean, if this goes through, we don't have the ability, housing authorities don't have the ability, businesses, mom and pop shops, whomever, don't have the authority to cure an alleged violation before they get sued, we'll start closing down. I mean, they'll stop doing Section 8 housing because they won't be able to afford it at the local government level. I mean, I'm just telling you from a Joint Budget Committee member perspective, if we're opening up a homeless transitional housing facility out at Ridgeview And we think there's at least 100 people that could be in that facility, and I think they're trying to even make it more than that. And we start getting violations, and they start adding on to this, and there's this 50, I mean, it's up to 5,000 per violation. So I don't know if that means if it's a violation on Monday and a violation on Tuesday, is that 2 violations or is that just 1 violation? If it's a violation on Monday and then again the next week they find another one, is that another 5,000? I don't know what the economic loss, I said it's up to 50,000, but for public entities and business entities that are trying to do what's right, I think saying that they can't get sued until they have failed to cure the alleged violation. And it's not like they're allowing, I just think this would be fair. And I understand, maybe I'm a little late to the game, but I'm not in committee. And I'm at the Joint Budget Committee. And I just now saw this, and I've had the opportunity to read through this. I was looking at it in appropriations, but we try and whip through those bills like this. So, you know, we start at 8 o'clock and we have like 15 bills and we're trying to be done by 9 o'clock. So it's not like there's a whole lot of discussion that occurs other than from me at those appropriation meetings that I'm sure everyone doesn't really appreciate. But this is why I start asking these questions. These things have great impacts, and it's not just to our budget. You need to start thinking about, do we start shutting down housing because they can't deal with the violations? And all this amendment says is they should have the opportunity to cure the alleged violation. I think that's fair. And just because it hasn't come up someplace else doesn't mean we shouldn't be debating it and having the discussion here on the floor about it. This is where I get the opportunity to have debate and have the opportunity to say, whoa, maybe we should slow down here a bit. This is where we have the opportunity to do this, all of us. So I would ask for an aye vote on L016.
Senator Frizzell.
Thank you, Mr. Chair. I rise in support, of Amendment L016. And let me tell you why. You know, in Douglas County, we have a lot of housing needs, very diverse housing needs. And we do have a housing authority, the Douglas County Housing Authority, appropriately named. And the Douglas County Housing Authority has done some really, really interesting things from a financial standpoint in order to house those who qualify or who need affordable housing. And sometimes they enter into partnership agreements for new construction, but just as often they enter into partnership agreements to purchase existing apartment complexes that have, maybe they're a little long in the tooth. They've been around for a while. And they work to update them as best as possible. But these are generally older apartment complexes. And this amendment is really, really important because it offers them the opportunity to, let's fix this. We've even talked about this when it comes to creating affordable housing from a multifamily standpoint. Condos, right? It's like the right to repair. Well, this really isn't any different. It just candidly takes the attorneys out of the game, and we don't need to be a more litigious society here in Colorado, because golly, we're up there. But let's offer the opportunity, whether it's the state or a local housing authority or a local government who is providing housing. Let's not penalize them. Why would we do that? How is that helping? Because I will tell you that if we run into situations like with the Douglas County Housing Partnership or fill in the blank housing partnership, because they're all over the place and they're all doing the same thing, providing housing that is affordable, why penalize them? Give them the opportunity to fix it and move on. This is a great amendment. It's really important. I ask for your aye vote on Amendment L16.
Senator Carson.
Thank you to my colleague from Castle Rock. I think this amendment really sets up a good framework to work with small business, to work with housing authorities, to work with other entities and not have the heavy hand of litigation come in immediately. And so I would urge my colleagues to support this amendment L016, and I call for a division.
A division has been requested. A division has been requested. All those in the chamber not entitled to vote, please be seated. The motion before the body is the adoption of Amendment L16. All those in favor, please stand. Please be seated. All those in favor, please stand. Or all those opposed, please stand. The chair is not in doubt. Amendment L16 is lost. To the bill, Senator Frizzell.
Thank you, Mr. Chair. So I was also in the Judiciary Committee hearing when we heard this bill, House Bill 251239, and I appreciated my colleague from Highlands Ranch's previous amendment because I think it made a lot of sense. One thing that I think is important as we talk about this and the fines and penalties that are created through this litigation.
Members, we are on seconds. Senator Frizzell.
Thank you, Mr. Chair.
Okay.
I get my chief problem. I don't have a problem making sure that we provide safe environments for those with disabilities. I have no problem with that whatsoever. I think it's really, really important that we ensure that those who are most vulnerable amongst us are provided a living environment that they can feel safe in and thrive in. That's not what this is about. My chief problem is that this bill jumps right to litigation. There's no stop-go. It jumps right to litigation. And I think it's okay if we just tap the brakes a little bit. I mean, can we not do that? We've talked a lot about already the problems around penalties with government entities. And I talked just a moment ago about my local housing partnership that does an amazing job for the citizens of Douglas County. There are housing partnerships, and I'm just talking about local government here. I'm not even going to talk about the state because my good colleague from Brighton already had that conversation, and it's a valid one. In a time when we are really concerned about our state budget, this fiscal note is inadequate, in my opinion. That's my opinion. So we need to really look at the downstream effects of this, and I don't feel like this has been adequately vetted. I really don't. And with that, I have an amendment.
There's an amendment at the desk. Will the clerk please read Amendment L18?
Amendment L18, amending gross bill, page 3, line 27, strike A, and
Senator
substitute.
Frizzell.
Thank you, Mr. Chair. I move Amendment L018 to House Bill 1239.
That is a proper motion to the amendment, Senator Frizzell.
Thank you very much. Members, this is a really simple amendment. It builds a little bit off of my good colleague from Highlands Ranch's recent amendment. This amendment simply requires mandatory mediation before any legal action can be taken for any alleged violations. This is, what I just talked about, let's tap the brakes. Let's not go right to litigation. This amendment encourages mediation as a first step, which is often more cost-effective than going through full legal proceedings. Mediation can reduce the legal fees, not just for the person who's filing the claim, but for those who are responding and other associated costs. This is a means of minimizing litigation that's widely used today in all sorts of arenas, and I think it's equally applicable to this particular scenario. I would encourage an aye vote. I think that this is an important amendment and would ask for the co-sponsors' consideration.
Senator Doherty.
Thank you. We would request a no vote, just for all the considerations that we have already talked about. Thank you.
Senator Rich.
Thank you, Mr. Chairman, and thank you to the good senator from Castle Rock for bringing this amendment. It certainly makes a lot of sense. You know, you can resolve disputes through mediation and outside of the court, and it alleviates a lot of financial burden on the legal system. And I don't know why, unless this is a trial lawyer's bill, why you wouldn't appreciate mediation, you know, and not put this burden on businesses. And so thank you for bringing this amendment. I urge an aye vote on L018.
Seeing no further discussion, the motion before Senator Cattler.
Thank you, Mr. Chairman. What I'd like to talk about is it appears that there's an assumption that landowners or landlords or people who supply housing do these things on purpose. I don't agree with that. I don't think that's the case in most of these instances. And the idea that we go straight to a fine insinuates that in my mind. If we can start to look at, maybe it's a new landlord, maybe it's somebody that has never had a problem, mediation would help everybody involved with this. It seems to me like we can get more accomplished for the person who is having a problem by mediation on this first approach, on this first, on the first offense or violation, than we can by simply going to court, which takes an amount of time. And in the meantime, they're still having struggles with housing and or access or whatever the issue might be. Where mediation could be taking care of it. We have a meeting quickly, mediate the situation, the landowner fixes it, the tenant has a house or a room that they can get into. This is something we can do to speed the process. It seems like we would want that for the people that are having problems with housing. Please vote yes on Amendment L18.
Seeing no further discussion, the motion before the body is the adoption of Amendment L18. All those in favor say aye. Aye. All those opposed, no. No! The noes have it. Amendment L18 is lost. Seeing no further, Senator Frizzell.
Thank you, Mr. Chair. One thing that this bill does is it creates a time frame filing, a time frame for compliance. Well, it creates several time frames. It allows individuals 60 days to file complaints regarding public accommodations. But it also sorry, I lost my place. It provides a time frame for businesses to, if there is a problem found, for a business to mitigate. And that time frame is rather short and could be very challenging for most businesses to actually complete. So I have an amendment around that.
There is an amendment at the desk. Will the clerk please read Amendment L22?
Amendment L22, amend ring gross bill, page 5, line 10.
Senator
strike.
Frizzell.
Thank you, Mr. Chair. I move Amendment L022 to House Bill 1239.
That's a proper motion to the amendment, Senator Frizzell.
Thank you, Mr. Chair. This amendment's pretty simple. It just extends the compliance period for businesses with 50 or fewer employees, giving them 180 days to rectify any violations that they have been notified about. You know, small businesses, we talk a lot about small businesses in this building, and a lot of times it's around regulating business, unfortunately. And our small businesses, which I don't know if this is just me, but I consider small businesses the backbone of our economy. They're the mom and pops, they're the people who have started out small and grown larger. It's the person who has the hair salon on the corner, the banker who's been in your community for generations. This amendment just simply gives our small businesses a little more time to address compliance issues, helps them avoid some very, very significant fines and penalties that really are going to strain their resources. With an extended deadline of 180 days, the businesses can manage the expenditures, which may be nominal, but they are likely to be considerable and something that could very much adversely impact their operations. We heard in committee from different people who have had some really unfortunate experiences with litigation, and it was pretty frivolous, but yet they ended up having to pay inappropriately, in my opinion, and in theirs as well, just to be able to move on. And so I think that this at least gives them a time frame in which, if there is something actually wrong, that they can mitigate it and make sure that their place of business is in compliance with ADA.
Senator Carson.
I want to support the amendment 22022 and offered by my colleague from Castle Rock. Again, so if we're not going to have a prior notice provision essentially, and before we go into the litigation stage, let's at least give the small businesses and the other entities a reasonable period of time to comply. And remember, even if we give them 180 days, they're still going to have the 50% penalty, 50% of the 5,000 or the 50,000 penalty. So at a minimum, we ought to, give them that period of time to comply before we jump right in and assessing these penalties and these lawsuits and everything. So I think as some of my previous colleagues have said, the assumption is that businesses are doing this deliberately, and I don't think that's the case. I think a lot of folks are not aware of some of the issues here. If you're particularly in the small business arena, you may not be up to speed on all of this, and once you're notified that there's a problem, I think we give folks time to correct the problem. So I want to support the amendment 022 by my colleague from Castle Rock.
Senator Doherty.
We would ask for a no vote on this amendment. We believe that there is currently enough time to comply. Thank you.
Senator Rich.
Thank you, Mr. Chairman, and again, I want to thank the senator from Castle Rock. Your amendments have been very thoughtful, and I believe that this one actually allows some flexibility, and I don't understand why they can't have some flexibility and some notice instead of going straight to court. And I urge, and I vote on L022.
Seeing no further discussion, the motion before the body is the adoption of Amendment L22. All those in favor say aye. Aye. All those opposed, no. No. The noes have it. Amendment L22 is lost. To the bill, Senator Pelton.
Thank you, Mr. Chair. I didn't hear this bill in committee, but the discussion has kind of motivated me to step up and offer an amendment.
There is an amendment at the desk. Will the clerk please read Amendment L19?
Amendment L19, amend ring gross bill,
Senator
page 3.
Pelton.
Thank you, Mr. Chair. I move Amendment L019.
That's a proper motion to the amendment, Senator Lundin, or Senator Pelton, sorry, Lundin was on. Says name, sorry. Senator Pelton.
That hits.
Hey, I was just looking at the name, sorry. Senator Pelton.
Thank you, Mr. Chair. Everybody knows my district, very small, very rural, frontier. A lot of businesses in my district fit under the protections of this amendment, which what it does, if you have 50 or fewer employees, it protects you from financial penalties for the first time of violations. And if they can demonstrate good faith efforts to comply with the requirements of this bill, then it gives you some relief. Out in my small rural frontier counties, communities, it's pretty tough to make a living out there. And if they're doing, if they happen to go against the crime that this bill talks about, but they try to remedy it, I think that they ought to be given some leniency in that way. So with that, I'd ask for support for 019.
Senator Liston.
Thank you, Mr. Chair. Well, members, I rise in support of Amendment L019 on House Bill 1239 for the reasons that, number one, anybody can make a mistake. We all know that. We've all made mistakes. And what this amendment is simply just trying to do is that you have small businesses. When you have 50 or less, it's really a lot of businesses that could be 10 employees or 5 or whatever, I don't know of any businessman that sets up a business that is trying to rip off the public from day one. I know that unfortunately, there may be some bad actors out there, but 99% of small businesses, all they're trying to do is provide a legitimate service or product to potential customers. And if they do make a mistake, then let's give them a reasonable amount of time to rectify that mistake, and let's not slap them down with a $5,000 penalty or even half, $2,500. This is reasonable. Surely, and with the other amendments that have been offered here over the past 30, 40 minutes, it just seems that it's unfortunate. I don't think this is the case that the sponsors want, but it's been talked about. Unfortunately, the environment that Colorado businesses are in now. We used to be a highly regarded state for being pro-business. We're not anymore. We've sunk from, I think it used to be number 6 down to the mid-20s. Well, after all of these other bills that have come through, we're going to sink even lower. So let's be reasonable. Let's be compassionate and understanding. It's all this amendment does is if a small business, 50 or fewer employees do make a mistake, let's give them a chance to rectify it, which, we look at all the other bills that we have that we've been, that we're willing to give youthful offenders added leeway and other offenders and so forth. If we can do it for other people, why can't we do it for small businesses? With that, Mr. Chairman, I would urge an aye vote on Amendment L019. Thank you.
Senator Carson.
Thank you, Mr. Chairman. I also would like to speak in favor of Amendment L019 offered by my colleague from Cheyenne Wells. As we were discussing earlier, probably nearly all of the businesses in his district are 50 employees or less. And this amendment really gets to that issue of saying, for a true small business out there, 50 employees or less, let's not impose this regulatory litigation penalty regime, whatever we want to call it, on these small businesses, particularly in small towns and rural areas. This amendment protects businesses with 50 or fewer employees from financial penalties for first-time violations if they can demonstrate good faith efforts to comply with the requirements of this bill. And that should be what we truly want here, is good faith efforts to provide more reasonable accommodations for customers, community members, whatever it might be there. The amendment helps small businesses with 50 or fewer employees avoid costly financial penalties for first-time violations by allowing these businesses to demonstrate good faith efforts to comply It'll encourage them to improve their practices without facing an immediate financial burden. This flexibility is crucial for our small businesses that often struggle to maintain operations and support their employees. The amendment will help to ensure we don't stymie economic growth and potentially even damage small businesses to the point where they can't continue operating. And, you know, I have heard references throughout this discussion about, well, $5,000, that's not a huge penalty, or we go all the way up to the potential $50,000 level for non-economic damages. And, you know, that is a lot of money for small businesses. We've heard from colleagues here who are operating small businesses. You know, I recall the discussion by my colleague from Platteville about his small businesses and how much money they have just lying around to continue operating their business as well. A $5,000 fine, that's a decent chunk of money. And even if you come in and work to correct this under this framework, you only get a 50%, even if you fix the problem, you only get a 50% reduction in the fine, so we're not going to allow for a prior warning, if you will. We're not going to allow for, you know, reasonable period of time to comply. We're just going to impose all of these penalties and burdens on small business. So I think at least at a minimum, we ought to say, as this amendment does, that for our small businesses of 50 employees or less, they would be exempted from these onerous provisions in the legislation. So I would urge my colleagues to support this Amendment 019 by my colleague from Cheyenne Wells.
The Senator Catlin.
Thank you, Mr. Chair. Members, I'm here on this amendment to speak to my district. My district is a rural district. Most of the businesses there are not very big. The jobs that we've got are critical. And, you know, the idea that slap a fine on, live with it, and get, you know, grow through it, I guess that works in some places. But it seems to me like we get more cooperation from people by showing some flexibility rather than the heavy hand of just write a check and you'll be okay. You know, I guess after an individual has been offered the hand of flexibility and they refuse to take it, then I see the purpose of fining people, fining companies. But before we do the fining, it seems to me we should be taking a look at, does this individual, does this business, are they in the process of good faith trying to fix the problem that we've noticed that they have and told them they have that problem? We're trying to talk about affordability in the state of Colorado. We're talking about access and having housing. There are a lot of folks that, you know, one $5,000 fine and they'll just walk away, sell out, and somebody else can take care of it. We shouldn't be looking at that. I think we should be trying to get things fixed rather than placing a fine. I know in private business, those are the kind of negotiations that end up having good, they end up having good results for everybody. Just to be fined for something that you may not have done on purpose seems like a heavy hand of government. And if we are going to be the free state of Colorado, we need to think about some of these kind of ideas too. We need to be flexible too. Thank you. Please vote yes on
Senator Liston.
1918.
Thank you, Mr. Chair. You know, I normally don't come down here again on second reading, but I just wanted to appeal to the sponsors. You know, there's been a lot of good points made, but in all sincerity to the sponsors, that this really is a fair, decent amendment, I would ask that you show, show some empathy, show a little bit of heart if you can, show some compassion, and give a little grace to the small business owners. That's all we're asking for. So in all sincerity, I hope you would do that. I would ask for an aye vote on Amendment L019. Thank you, Mr. Chair.
Senator Carson.
I want to make a point, too, about, I mentioned my colleague from Cheyenne Wells and his largely rural district and the need to exclude small businesses, but that applies as well to my district. Douglas County, when you do studies of businesses, it is interesting that the vast majority of businesses out there that are creating jobs and boosting our economy are 50 employees or less. And so I don't want to leave the impression that this is just for a particular communities in the state. I think this type of provision is critical in suburban areas like Lone Tree and Highlands Ranch and Sterling Ranch. And we've got businesses starting up all the time. And, some of these laws may apply more to older businesses, but sometimes new businesses will start up and occupy in older buildings that might need to be more accessible to the disabled. But you might get into a building like that as a new small business person, and you don't realize that's one of the first things you got to deal with. And so I think it's reasonable to say to those smaller businesses starting up, creating jobs, let's have a more reasonable approach to this type of law. And so I once again urge my colleagues to support Amendment 019.
Senator Pelton.
Thank you, Mr. Chair. The good senator from Highlands Ranch is right. This amendment does spill over into the cities, the Front Range, small business, because small business is the engine for this economy in this state. And I want to bring it back now to rural Colorado. We talk about economic growth all the time. Up here on the Front Range, economic growth happens very easily. In my district, in rural Colorado, a lot of times economic growth is just retention. Retaining the businesses that are already there, and a $5,000 fine to a lot of these small businesses will shut them down. So we lose business, we lose employees, we lose an economic base in that community. So with that, I urge support for 019.
Senator Weissman.
Thanks, Mr. Chair. It's disheartening to see that folks with disabilities receive so little consideration here in the framework of legal remedies. I'll just point out that part of what we're talking about denying to folks is actual monetary damages, not the other stuff, not a statutory fine, not non-economic loss capped as it is, but actual damages that people have to prove that they suffered. And then this would come in and say, no, because you're a person with disabilities, you don't rank. I think that we should do better than that in Colorado. I'm going to ask for a no vote.
Seeing no further discussion, the motion before the body is the adoption of Amendment L19. All those in favor say aye. Aye. All those opposed, no. The noes have it. Amendment L19 is lost. Senator Carson.
Thank you, Mr. Chairman. I'd like to revisit the costs of this legislation to the state, to the taxpayers, and go back to what our colleague from Brighton, from the Joint Budget Committee, was talking about earlier, because I think this is a very important point. And the new fiscal note is interesting to me. It says in here The settlement costs are $5,000 in 26-27, $5,000 in 27-28. The non-economic damages are $50,000 in 26-27 and $50,000 again in 27-28. Now, and they're putting only a number of $100,000 on the legal services. Well, I would suggest to you that we're going to be looking at much bigger numbers than this. And I do recall seeing an earlier fiscal note. Yes, here it is, fiscal note from February. We've got a new one here from March, but the one from February I think is probably going to end up being a lot more realistic of the kind of numbers we're going to be looking at here. You know, they've got million-dollar numbers in here, 26, 27, 1.5 million, 27, 28, 2.2 million. So I don't know exactly how the adjustments were made on this, but if you look at the kind of litigation and the kind of costs, I mean, basically the numbers in this new fiscal note are one case, one $5,000 fine potentially, another one maybe of $50,000 in the punitive damages, the non-economic damages category. So these are pretty low numbers, and when you look at the legislation, they do acknowledge that the bill is expected to increase litigation and risk management costs to the state from additional discrimination lawsuits. If such cases occur, state agencies and institutions of higher education, let's not forget that too. We've got the universities will be under the rubric of this legislation. They'll have increased costs for legal services provided by the Department of Law, so clearly there are going to be more personnel costs, there are going to be more litigation costs to the state. As the fiscal note acknowledges, there may be settlement costs, but damages costs to the state. But this could go on quite a while. As the fiscal note also addresses, the state of Colorado owns more than 9,000 properties, at least 1,400 of which were built prior to 1991, which was the date of the Americans with Disabilities Act. And so what we're putting into place here with this legislation is no doubt going to end up costing us a pretty penny here for the budget situation. And I just want to once again reiterate the warning that the senator from Brighton gave us about some of the costs and how I think this fiscal note is really underestimating the burden of that. Mr. Chairman and colleagues, I want to turn back now briefly to the small business issue. We talked about the cost to the taxpayers and to the state, but as we've made a number of points here, the small businesses need to be considered. So I have an amendment here at the desk on this issue again.
I can't wait for us to see it. There's a member at the desk. Mr. Schaffler, please read L17.
Amendment L17, amending gross bill, page 4, line 14.
Senator Carson.
Thank you, Mr. Chairman. I move amendment L017.
To the amendment.
So this amendment addresses the amount of the penalty. So the bill has the $5,000 initial fine in there. And this amendment says that if the defendant is a business with fewer than 50 employees, again, we come back to that important level for small business here, the biggest job creators in our state, by the way. If they have fewer than 50 employees, then the statutory fine is going to be $2,500 rather than the $5,000 that's currently in the bill. And so I think that's, you know, we've gone through different amendments here. We've said we're not going to do the prior notification. That was the amendment I initially offered. Then the senator from Castle Rock offered an amendment giving folks a more reasonable period of time, 180 days instead of 120 days. And we've had amendments dealing with exempting small business. So we're not going to do any of that. Let's at least have a more reasonable fine level. And this amendment proposes we come in at the 2,500 level, which I think is a positive addition to the bill.
Senator Doherty.
Thank you. We would ask for a no vote on this amendment just based on the previous discussions that we've had. Thank you.
Very good. Further discussion. Senator Carson.
Thank you, Mr. Speaker.
I mean, I'll take that.
Mr. Chairman.
I'll take that as well.
Dual roles. So I will once again ask for support on this amendment. L017 reduces the initial penalty from $5,000 to $2,500, and I ask for a division on this vote.
A division has been requested. Somebody yell out there. A division has been requested. All those in the chamber not entitled to vote, please be seated. The motion is adoption of L17. All those in favor, please stand. Please be seated. All those opposed, please stand. Oh, man. The chair is not in doubt. The motion for the adoption of L17 is lost. Further discussion? Seeing no further discussion, the motion is the passage, adoption of 1239. All those in favor say aye. Aye. Opposed, no. The ayes have it, and 1239 is adopted. Mr. Schaffel, please read the title of House Bill 1239 is adopted. Mr. Schaffel, please read the title of House Bill 1279.
House Bill 1279 by Representative Stewart and Senator Judah concerning collecting state-level data for Colorado Workers Program and in connection therewith making an appropriation.
Senator Judah.
Thank you, Mr. President. I move House Bill 1279 and the committee report.
To the Health and Human Services Committee report, Senator Judah.
We passed an amendment that clarifying types of outcomes and methods for providing data, clarifies that recommendations will be developed and required levels of effectiveness for third-party contracts rather than levels of evidence. And finally, it clarifies that to the extent possible, data and information will be shared through existing county financial management systems and otherwise through process developed during the process outlined in the bill. And I ask for an aye vote.
The motion is the adoption of the Health and Human Services Committee report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Health and Human Services Committee report is adopted. To the Appropriation Committee report, Senator Judah.
They appropriated money that we needed, and I ask for an aye vote.
Excellent. The motion is the adoption of the Appropriation Committee report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. The Appropriation Committee report is adopted. To the bill, Senator Judah.
Thank you, Mr. President. So today we're here to talk about the TANF program, which is the Temporary Assistance for Needy Families. It is a federally funded program for families with children living far below the federal poverty level. It's also known here as the Colorado Works Program. Families receiving financial assistance called Basic Cash Assistance, or BCA, are living extreme poverty. A parent with 2 children must make less than $421 a month to qualify for BCA. And Colorado's TANF program is county administered, meaning the majority of TANF federal funds Colorado receives are allocated to counties to implement the program at a local level.
Senator Bright.
Thank you, Mr. Chairman.
There we go.
And Senate President.
Oh, just chair.
Okay, thank you. Having seen firsthand the incredible positive impact that TANF has on needy families in Colorado, helping them get back up on their feet, I definitely wanted to jump on and sponsor this bill. What does this bill do? Well, it requires the Department of Human Services in consultation with the Works Allocation Committee to develop a standardized process for CDHS and each county to collect and report information about the Colorado Works program, including how dollars are spent and the impacts of policy changes. This bill also requires regular public reporting of the data and information collected under the established process, as well as the feedback loop on the data with the WAC each year. And I feel like in the spirit of effectiveness and efficiency, this bill does exactly what we need to do to keep those folks accountable and to keep this flowing.
Very good. Seeing no further discussion, the motion is the adoption of House Bill 1279. All those in favor say aye. Opposed, no. The ayes have it. House Bill 1279 is adopted. Mr. Schaffel, please read the title of House Bill 1321.
House Bill 1321 by Representatives McCluskey and Byrd and Senators Bridges and Amabile concerning use of the Infrastructure Investment and Jobs Act, cash fund, to support the state's defense against adverse federal action and in connection therewith making an appropriation.
Senator Bridges.
Thank you, Mr. Chair. I move House Bill 1321.
Any discussion? Senator Kirkmeyer.
Thank you, Mr. Chair. Members, where do I start? Where do I start? Members, I rise in opposition to this bill. And this is not a JBC bill, just so you understand. So we did set aside $4 million at the Joint Budget Committee to allow the governor to have the opportunity for what I thought was to provide legal services for those state officers or employees that might get caught in the middle. This is how it was explained to me. They might kind of like just get caught in the middle. And they need the state officers or state employees. And I'm just going to use the example that was used as the example that I was given. Let's say the executive director of the Department of Public Safety is held liable for a decision that he's made that is in compliance with state statute, but may be out of compliance with federal law or federal rule. There may be the case where they would need additional legal services to be able to provide for legal services for that employee, essentially, of the state. Because the State Attorney General's office does not necessarily provide legal services for state officers or employees. If you look in the statute, it's very clear that he provides legal services to state agencies. So again, this may be an area where they needed to be able to pay for outside counsel. They end up being, I guess, special assistant attorney generals, but there may be a need for additional money there. That's what I was told. Hence why the bill that we passed, I don't know what number for sure it was because I didn't pull the bill, but why the bill we passed was essentially a one-pager, right? To be able to put $4 million aside so that we could protect our state employees when they are acting on behalf of the state and doing their jobs and they're in conflict. That made sense. But then House Bill 1321 comes along. This is not a JBC bill. Even though it has 3 JBC members on it, not a JBC bill. And in this bill, the $4 million can be used for hiring and employing personnel or retaining contractors for purposes related to the federal government actions that impact federal disbursements, grants, contracts, or money received by the transfer of the state. And then there is, that's section 1, Roman numeral 1, Roman numeral 2, reimbursing the Department of Law for costs associated with special assistance for the attorney generals to provide legal services to state officers and employees. That's what I spoke about. Providing legal services for the criminal defense of state officers or employees. Again, that's what I was speaking about earlier. And then there's section 3, which says other expenditures consistent with the purposes of this section as determined by the governor, including expenditures to preserve and protect the state sovereignty or federal funding streams that benefit the state. Kind of starts sounding a little bit redundant, doesn't it? It really sounds redundant if you'd have been sitting in the Joint Budget Committee when the Department of Law, which is the Attorney General, came forward with a request, a decision item. This was back in January. We ended up talking about it more in March 21 of this year, but a decision item where they requested essentially 3 FTE at the cost of $640,000. And those 3 FTE do things like track and research and analyze federal actions that merit legal challenges or pose compliance issues for Colorado state agencies. Provide legal counsel to state agencies. Coordinate and advise on federal compliance to ensure continuing of federal funding streams. Analyze new and updated federal executive orders and directives that contain federal funding sanctions or penalties. Representing state agencies in appeals and administrative disputes when grants are terminated. So the Attorney General's office came in and said, gosh, we need 3 more FTE so that we can go do all this stuff because we're so concerned about what the federal government may do. They have not done, but may do. Now, I just want you to understand, first of all, that the Attorney General's office already has the responsibility to provide legal services to the state and protect the state. And we fund the Department of Law, so the Attorney General's offices, $94 million from reappropriated funds. $28.7 million straight from the general fund, and $4 million from federal funds. That's what the Attorney General gets. Now, he came in and asked for additional money, 3 FTE at $640,000. The governor, on the other hand, wanted $4 million. But to basically do what the Attorney General is supposed to be doing in the first place. But again, the Attorney General, on a 4-2 vote, maybe it was a 5-1 vote, but it wasn't unanimous, received through a decision item, 3 additional FTE on top of that $94 million, the $28.7 million, and the $4 million. On top of that, another 3 FTE on top of the 661 FTE he has. Another 3 FTE. To do what he was supposed to be doing in the first place. I mean, we reappropriate funds. We appropriate funds to departments, to state agencies, to essentially hire the Department of Law, the Attorney General, and his deputies and his special assistants and his assistants to go in and provide litigation and support for ongoing legal challenges, tracking, researching, and analyzing federal actions that merit legal challenges, litigating Colorado-specific litigation anticipated in the coming year. That's what we do during the budget process. That's what we do. And here's the other thing that we have in place in our state. It's called a supplemental. So when we're not in session, because we can do supplementals on our own as a legislative body when we're in session, but when we're not in session, let's say we missed the mark. We didn't appropriate enough dollars. We have the ability to do supplementals. They're called 1331 emergency supplementals. They're for the Department of Law, the Attorney General, or the executive branch to come in and say, we missed the mark. These are things that we weren't able to foresee. We don't have enough money in the budget. We need a supplemental so that we can provide additional legal services. Now, the Attorney General has been suing the federal government and doing legal actions already this year. And he didn't come in and ask for a supplemental, but he did say he needs more for next year. And that's what those additional 3 FTE on top of 661 FTE, on top of his guessing what he needs for next year budget, wants another 3 FTE on top of that, and that decision item passed. So it's beyond me why we need to give $4 million to the governor's office to basically do other expenditures consistent with purposes in this section as determined by the governor. Just $4 million bucks. But it's really beyond me why we would have to do money to hire and employ personnel or retain contractors for purposes related to federal government actions that impact federal disbursements, grants, contracts, or money received by or transferred to the state. Because if we've got legal action there, if we need assistance there, the Attorney General is supposed to have it covered. And you got 3 additional FTE to help with that. I was reading directly from the decision item why he needed 3 more FTE.
There is an amendment at the desk. Will the clerk please read amendment number 013?
Amendment 013.
Senator Kirkmeyer.
Thank you, Madam Chair. I move L013.
To the amendment.
Thank you, Madam Chair. This amendment removes section I, Roman numeral I, eliminates it, strikes it from the bill. I is the one that says hiring and employing personnel or retaining contractors for purposes related to the federal government actions that impact federal disbursements, grants, contracts, or money received by or transferred to the state. First of all, we don't need additional funding to do this for the Attorney General. We already took care of that in the long bill. That already happened. That already happened in a decision item that came forward that was voted on and approved by a majority of the Joint Budget Committee members and got put into the long bill. So we don't need it for that. And in case you weren't listening, here's what the Attorney General gets to do with the money that he received and the additional 3 FTE that he received in the long bill for these purposes. Track, research, and analyze federal actions that merit legal challenges or pose compliance issues for Colorado state agencies or institutions of higher education. Coordinate and advise on federal compliance to ensure continuing federal funding streams for Colorado state agencies. Analyze new and updated federal executive orders and directives containing federal funding sanctions or penalties for noncompliance, and develop corresponding, and it's an and, it's not an or, and develop corresponding legal advice to state agencies. Represent state agencies in appeals and administrative disputes when grants are terminated, paused, or disrupted by the federal agency. So we don't need additional funding for that because we covered that. We gave the Attorney General, on top of the approximately $130 million or so that he receives from either general fund, reappropriated funds, or federal funds, we already gave him even more money and more staff to go do that. So we don't need it there. Now, some people are probably going to get up and argue, yeah, but our state agencies need that. I will tell you that Healthcare Policy and Finance has already put together a matrix and already put together areas of where they believe that we could be impacted by any federal decisions, any changes in rulemaking that happens, any executive orders that may happen. They've already put it together. They've already put that list together. Department of Human Services knows what it is as well. Department of Education, they all know where their federal funding has come from. We just went through a budget experience, putting together the long bill, hearing from them, having briefings, hearings, documentation. They know where all their federal funds are. They know where they're coming from. They know what the rules are. Heck, we're going to hear some more bills later on. Not today, hopefully, but later on, maybe in committee or here in the Senate, that talks about they're dealing with impacts of federal funding, whether it gets increased, whether we get a waiver, whether our grants are paused. They know. That is their job to do. They're already supposed to be doing that. I do not understand why we need to hire and employ more personnel, retain contractors for purposes related to when the federal government actions may impact federal disbursements, grants, contracts, or money. We didn't do that with the public health unwind. You know, we just went through a period with a different president who passed through a bunch of federal dollars, ramped up all these federal programs, impacted the state, and then we went through that huge unwind. We've all been hearing about the unwind, the redeterminations. We didn't need to go then. We didn't need to do that under President Biden when he made that decision. We didn't need to have a contractor or hire more personnel or employees or retain contractors when they said we're going to decrease the SNAP program and the money and take it back down to what we were providing prior to COVID. We didn't need anybody to do that for us when it was under President Biden. But now a new administration that has not done any of this yet. They've been having discussions, which is normal, which happens, which then states have the opportunity to have an understanding or influence or have discussion with regard to new rules that would come out. We think it takes a while to get a law through at the state. Think how long it takes to get a law through at the federal government. Think how long it takes to get a new rule or regulation passed at the federal government. This is not going to happen tomorrow. It's not going to happen tomorrow. But even if it does, our state agencies are on top of it. We don't need to hire a contractor to do that. This is what our state agencies are supposed to do. They should know all the ins and outs of those federal rules and regulations, all the ins and outs of those grants that we receive, or those waivers that we are receiving, because we have to comply with them. So I am asking that we strike Section 1 of this bill. It's not necessary. It is not necessary. I don't agree with the whole bill, but I at least do agree partially with trying to hire outside counsel. That might be a realization that needs to happen, and we need to be prepared for it. I'm not sure why we aren't prepared for it, because just so you understand, in the law right now, the Attorney General under Section 24-31-101 already has the authority in statute to hire a special assistant attorney generals. And under 24-31-111, Section 5, the governor already has the ability to ask the attorney general to hire people. And we have the ability to do supplementals if we find out, God forbid, something happened and we need to fund additional money when we are not in session. So we do not need to give the governor the authority to go out and hire a bunch of more people, $4 million worth. He doesn't need that. So I'm asking for an aye vote on L013, which is repealing or striking Section 1 of 1321. Ask for an aye vote.
Is there any further discussion? Senator Bridges?
Thank you, Madam Chair. Yeah, if this were normal times, I would totally agree. We have folks in staff in the executive branch who track these various grant programs, what the rules and the regulations are. But what has never happened before is the federal government suddenly, unexpectedly changing the rules and regulations around all sorts of different grant programs, repealing grant programs. The AgWell program, you may all have heard about this. The AgWell program just lost $10 million, just suddenly out of nowhere with no explanation or sort of like roll-off period given. This is not the way that our state government is set up to respond to the support we get from the federal government. This is not the normal course of business, and given these changes, we need more support in our executive branch to respond to changing regulations, to respond to the elimination of grant programs. We had, just a couple of months ago, all of a sudden, we lost a ton of money for behavioral health care, and we have a lot of employees in the state that depend on those dollars. And what happened is the state rules require us to continue paying those folks with at least a 30-day notice. But if the Fed shut off those dollars out of nowhere, we're on the hook for paying those employees for another 30 days. Because we're going to follow the state law. We're not just going to fire those folks because the Fed shut off the dollars. We need resources in place here in the state to respond to unprecedented federal action. And whatever you think about that federal action, this is not a commentary on that federal action. This is simply the reality of what we need to have in place here in the state in order to respond effectively to this rapidly changing, unprecedented environment. Ask for a no vote on the amendment.
Further discussion? Senator Kirkmeyer?
Thank you, Madam Chair. We actually did respond very quickly when those things happened, and we were able to take care of it, and then they actually did not even happen. So we have that ability to already do that. And again, all of our state agencies have, and if they don't have an understanding of their grant programs, all the federal rules and requirements and regulations that go with all those, all the strings attached to it, everything attached to any waiver that they're receiving, we've got a different problem. But they already know. We have a bunch of statutes that talk about how we implement those programs. We have processes in place, and I'm just going to remind you, when we went through the public health unwind under the President Biden administration, where nearly 600,000, it was 567,000 or something, individuals were determined not to be eligible for Medicaid, we didn't go out and hire or employ personnel or retaining contractors for purposes related to the federal government actions. We didn't do that. We did not do that. This has not happened. I will tell you what we did do when the Department of Early Childhood and the Early Intervention Program overnight tried to blame the Joint Budget Committee for not budgeting enough money for the Early Intervention Program. We had an emergency meeting of the Joint Budget Committee and got it straightened out within a couple of days. So we have the ability to react quickly. We have the ability to fund additional money should we not be in session. We have that ability now. There is no reason to sit here and suppose that things are going to happen, that they're going to happen that fast. It didn't happen under the Clinton administration. It didn't happen under the Obama administration. It didn't happen under the Biden administration. I don't know why it needs to happen now. So I ask for an aye vote on this amendment, that we don't hire and employ additional personnel, that we don't just wave a wand and give the governor basically $4 million of just money sitting out there that he can go do whatever he wants with. We've been there, folks. We have been there. Billions of dollars of COVID monies that came to us went directly to the governor. They're called custodial funds. In fact, the Attorney General has custodial funds. We don't appropriate those. He's got funds to take care of all sorts of things. We don't even know what he spends those funds on for sure, until all of a sudden something might show up at the Joint Budget Committee that now we need to have ongoing general fund for. So we've already been in this situation where we hire people and where we start new programs or where we look at things and hire contractors. And it's supposed to be one-time money, and all of a sudden it turns into ongoing general fund money and puts us into a structural deficit. We need to be watching every single dollar we spend. This is not watching the taxpayer dollar. So I ask for an aye vote on this amendment.
Mr. Minority Leader.
Thank you very much, Madam Chair. I rise in support of Amendment 13. You have heard clearly that there is a financial custodial responsibility element that this amendment would seek to put us in a better position with regard to. I think that there are expansive challenges that go beyond that, and we'll speak to that as I offer an amendment to this bill as well. But I want to focus in here on this idea of financial responsibility and what we're doing. We're taking and setting aside $4 million to do what we already have funded. There is authority in the existing law, there is money in the existing budget, and this is a step too far, a bridge too far. It is additional unnecessary dollars. I will speak to the authority over those dollars in a moment, which is part of, I believe, why the money is there. But first step in the process is let's get rid of the money. If we get rid of the money, then the expansive, overweening authority that the bill also provides becomes less important. So in a kind of a 1-2 punch at actually trying to solve the bad policy and the bad finance policy of this, I urge your support of Amendment 13. You want to divide it?
Is there further discussion? Seeing no further discussion, a division has been requested. A division has been requested. All those in the chamber not entitled to vote, please be seated. The motion is for the adoption of L 013. The motion is for the adoption of L 013 to HB 1321. All those in favor, please stand. Sure. Thank you all. You all may be seated. All opposed, please stand. The chair is not in doubt. The motion for the adoption of L 013 is lost. To the bill. Mr. Minority Leader.
Thank you very much, Madam Chair. In the discussion continues, the effort to make the bill better continues.
There is an amendment at the desk. Will the clerk please read amendment number L 012?
Amendment L 012, amending re-engrossed bill, page 3, line 5, after state, insert or, page 3, line 17, strike decisions or and substitute decisions. Page 3, strike lines 18 through 21.
Mr. Minority Leader.
Thank you very much, Madam Chair. I move Amendment 12 to 1321. Colleagues, as you heard the reader just say, if you will turn with me to the re-engrossed bill, page 3, we're going to clean this up a little bit. And what we're going to clean up is we're going to strike a section that gives essentially what I would describe as going beyond the scope authority to the executive. Now, the representations of the bill's sponsors are that we've got this very narrow thing we need to do. It's about making sure we get all the money from the federal government because they print it out of thin air and we should grab as much as we can. But the bill also says, and the governor can do whatever he wants with this money. He could say, you know what? The executive branch is seeking to get greater public exposure in the process of having an influence on what politics might look like in Colorado. We have the ability to influence the primary elections in a state by having greater visibility for individuals who might be the law enforcement folks. And they might benefit from us spending additional dollars seeking to hold against the big, bad, ugly Uncle Sam. That in fact, it might be popular in a Democrat primary to in fact be pushing back against the federal government. And we need money to do that. Okay, so we've got a band of potential outcomes with this bill. You've heard the best arguments from the bill sponsors. We need to make sure we have the money to file the lawsuits, to do what we can, to collect the money we would like to collect from the federal government. That's the best possible outcome. At the other end of the band, the worst possible outcome is we are spending taxpayer dollars on behalf of potentially influencing primary elections by raising the profile of individuals filing lawsuits and fighting lawsuits in a way that would be very popular against an unpopular Republican administration at the federal level on behalf of a potential future Democrat administration at the state level. This particular amendment says, wait a second, not so fast. Take that bit out. Take that going beyond the scope. If you really want to just defend and make sure you collect the federal money you ought to be collecting, well, that's fine. Go ahead and do that. I argue, as I did on the previous amendment, you can do that with the existing means that the Department of Law specifically already has. This particular amendment says, bring the scope of authority on where you may spend the money, the unnecessary $4 million, down. It strikes out what I would call excessive authority for the governor. I urge your support of amendment number 12.
Senator, Senator Kirkmeyer.
Thank you, Madam Chair. Members, I rise in support of L012, L12, and here's why. When we talked about the need for this money, and maybe I don't think I misunderstood, but we were told it was to provide outside counsel legal services for state officers or employees related to legal proceedings. That made sense to me. As a former county commissioner, had to do this a couple of times when we needed outside counsel because the county attorney couldn't be the county attorney for both the, let's just say the sheriff and the Board of County Commissioners. So we had to hire outside counsel. That makes sense. You know, if there's a federal law or state law that's in conflict with federal law, our employee shouldn't be caught in the middle. That part made sense. That's why I agreed to the $4 million set aside. But this last part, basically where the governor gets to use it for whatever and, you know, sue the feds, essentially, that was not, I didn't know that that was part of the deal. And I don't recall that being mentioned of it being part of the deal. Certainly it was not said in these terms. I'm pretty sure I would have caught it. So that's why I support L12. This is not necessary. We have an Attorney General's office who has the ability to do this already, and he's already been doing it. I think he probably has his name on 2 or 3 or 4 lawsuits right now. Either he's starting them or he's joined into them. He didn't need additional money for those. He went and did it. So this is just not necessary. It's not what I thought the set aside was supposed to be used for. It's not what we were informed that it was going to be used for. In fact, I didn't see this until this bill came out. The Attorney General can do this. He's already doing it. The governor doesn't need to be able to use money in this manner. We have a Department of Law that does this. I would ask for an aye vote on L012.
Senator Amabile.
Thank you, Madam Chair. This section that this bill is taking out is what is providing some flexibility. And I would just like to remind my colleagues that we have seen this administration do things that have never happened before. And we don't know what's coming next. So we don't want to limit our ability to respond to the things that come our way. And we owe it to the people of Colorado who have paid faithfully their federal tax dollars. We owe it to them to make sure that we get everything we are owed and everything we need to care for the people of Colorado. That is our job. I ask for a no vote on this amendment.
Is there any further discussion? Seeing none, the motion is the adoption of Amendment 0012. All those in favor, please say aye. Aye. Those opposed, no. No! The noes have it, and the amendment is lost. To the bill, Senator Amabile. Senator Rich.
Thank you, Madam Chair. Of course, I rise in opposition to House Bill 1321. You know, this money, this $4 million is coming from the Infrastructure Investment and Jobs Act. And all this time, we thought that that money would be going to the state's roads and bridges. But here we are. It's going to go to the governor's office to fight the president's decisions, just in case. You know, let's cover all bases. I heard the Speaker of the House say that on TV. This year, the General Assembly had to decide whether to fund out or cut several programs that directly benefit citizens. Items with relatively low costs of $400,000 and $1.2 million were viewed as luxuries and were rejected for appropriations. $4 million is almost 2/3 of the amount in the legislative placeholder, and if this money has to be spent, it seems to me there's better ways to do this. Allowing the governor to hire contractors will inevitably lead to an increase in full-time employees. During JBC hearings, transitioning contractors to full-time employees is often touted as, get this, cost savings measure. The governor will likely suggest transitioning the contractors hired per this bill in his November budget request next year. And if those proposals are accepted, another amount of FTEs will be nearly impossible to eliminate and will require ever-increasing wages and benefits each year thereafter, extending long past the current president's tenure. I, like the good senator from Brighton, believe the Department of Law is responsible for defending the state of Colorado in court. And I don't understand, but I do see on a daily basis the spending addiction that goes on. And I am sorry a bill like this has to come forward. One of the things I'd like to say, though, because everybody's so upset that, oh, they might not get the federal money that we're due. Well, think about the taxpayers that are not going to get their taxpayer Bill of Rights refunds. They probably feel the very same way. I urge a no vote on House Bill 1321.
Senator Amabile.
Thank you, Madam Chair. Members, this is a good bill that is going to help our state protect our citizens and make sure that their tax dollars, their federal tax dollars, come back to them in the way that they think they're going to, in the way that they were intended, and going forward so that we make sure we get everything we can to support our citizens. I ask for a yes vote.
Is there any further discussion? Seeing none, the motion is the adoption of HB 25-1321. All those in favor, please say aye. Aye. All those opposed, no. No. The ayes have it, and the bill is adopted. Senatorial 5. Senator Roberts.
Thank you, Madam Chair. I move that the committee rise and report.
The motion before the committee is to rise and report. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the committee will rise and report. I won't run away.
Senate will come to order. Senator Wallace.
Thank you, Mr. President. I move for the adoption of the report. No.
The committee has met.
Mr. President, the committee has met and had a number of bills under consideration. Will the clerk please read the report?
April 24, 2025. Mr. President, in committee, the whole begs leave to report as had under consideration the following attached bills being the second reading thereof and makes following recommendations thereon. Senate Bill 11 as amended, Senate Bill 50 as amended, Senate Bill 64 as amended, Senate Bill 292, Senate Bill 295 passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. House Bill 1017 as amended, House Bill 1209 as amended, House Bill 1239 as amended, House Bill 1279 as amended, House Bill 1321 passed on second reading and ordered revised and placed on the calendar for third reading and final passage. Senate Bill 288 laid over until April 25, 2025 and retaining its place on the calendar.
We'll take a Senatorial 5. And we're back. Mr. Schaffler, please excuse Senators Winter, Cutter, Doherty, and Majority Leader Rodriguez. Now, back to Senator Wallace.
Thank you, Mr. President. I move for the adoption of the report.
The motion is adoption of the Committee of the Whole report. There's a member of the desk. Mr. Schaffler, please read S001 to Senate Bill 11.
Amendment S001, Senator Kirkmeyer moved to amend the report of the Committee of the Whole to show that the following Kirkmeyer floor amendment L8 to Senate Bill 11 did pass.
Senator Kirkmeyer.
Thank you, Mr. President. I move Senate Bill 11S001, Amendment 1.
To the amendment.
Thank you, Mr. President. Members, this amendment I'm asking for an aye vote on. It simply repeals the effective date, or it would repeal the effective date to July 1st of 2028 if the department does not receive at least $2 million in gifts, grants, and donations. For those of you who weren't here when we had this discussion, this bill, which I'm not necessarily opposed to the portions of the bill, other than it started off with a $6 million fiscal note that was to come from the unused state-owned real property fund, which originates as general fund. That got changed with an amendment to say it would come from gifts, grants, and donations. Now, I'm a little skeptical that the Division of Fire Safety is going to be able to get $6 million or even $2 million of gifts, grants, and donations to make this project work. And I'm greatly concerned that if they go get a vendor agreement in place because they get one gift, grant, or donation, that we could be liable for a contract and then have to put money towards a program that was supposed to be relying on gifts, grants, and donations, now ends up being general funded, essentially. So this amendment would say that the previous amendment, L08, that it did pass, and that if the department doesn't receive $2 million in gifts, grants, and donations within the next 3 years, then this program would be repealed. This is entirely consistent with action by the Joint Budget Committee when we have a bill that's coming forward that repeals inactive cash funds if they've been inactive for 2 years. This one is actually 3 years. So if it's inactive, it would be repealed. I would ask for an aye vote.
Further discussion on S001. Seeing none, the motion is the adoption of S001 to Senate Bill 11. Are there any no votes? Senators Amabile, Wallace, Danielson, Gonzalez, Judah, Amabile again, Kip, Michelson Janae, Henriksen, Weissman, Roberts, Sullivan, Snyder, Exum, Mullica, Ball, Colker. Please add the president. With a vote of 14 ayes, 17 noes, 0 absent, and 4 excused, S001 to Senate Bill 11 is lost. We'll take a senatorial 5. Yep. Senator Wallace.
Thank you, Mr. President. I withdraw the motion for the adoption of the report.
The motion for the Committee of the Whole report adoption has been withdrawn. Is that a vote? The motion is to withdraw the Committee of the Whole report motion. All those in favor say aye. Aye. Opposed, no. The ayes have it, and the Committee of the Whole report motion has been withdrawn. Mr. Schaffler, please add Majority Leader Rodriguez back to the roll. Mr. Schaffler, please excuse Senator Bridges and Senator Danielson. 40, Cutter, and Winter. Yeah, all right, now, we're all good to go? Senator Wallace.
Thank you, Mr. President. I move for the adoption of the report.
The motion is the adoption of the Committee of the Whole report. There is an amendment at the desk. Mr. Schaffler, please read S001 to Senate Bill 11. Same one.
Amendment S001.
Senator Kirkmeyer.
Thank you, Mr. President. I move Amendment 1 to Senate Bill, Cow Amendment 1 to Senate Bill 11.
Any further discussion?
Yes. For those of you who missed it, this was an important cow amendment. You all need to be here. You should be voting aye on this amendment. And all it does is says, hey, if they don't get their $2 million in gifts, grants, and donations, then we would repeal this. And they get 3 years to get their gifts, grants, and donations of $2 million. So I ask for an aye vote.
Mr. Minority Leader.
Mr. President, I feel a little bit like Yogi Berra. This feels like deja vu all over again.
Very good. Seeing no further discussion, the motion is adoption of S001 to Senate Bill 11. Are there any no votes? Senators Gonzalez, Michelson Janae, Kip. Yes, we are voting this again. Wallace. Kip again. Judah. Amabile. Mr. Majority Leader. Amabile again. Coker. Snyder. Henriksen. Weissman. Roberts. Mullica. Please. Oh, Exum. Couldn't see it, man. It was like this, man. There we go, Exum. Please add the president. With a vote of 15 ayes, 15 noes, 0 absent, and 5 excused, S001 to Senate Bill 11 is lost. There's an amendment at the desk. Mr. Schaffler, please read S002 to 1239.
Amendment S002. Senator Peltonar, move to amend the report.
Senator Peltonar.
Thank you, Mr. President. I move Amendment 002 to 1239.
To the amendment.
Yeah, thank you. You know, this amendment goes to protect businesses with 50 or fewer employees for a first-time violation. And so I would ask a yes vote.
Further discussion. Senator Weissman.
Thank you, Mr. President. Members, asking for a no vote, as we did in the discussion a little bit ago in the Committee of the Whole. What this says is that somebody who's injured, a person with disabilities who's injured, can establish actual damages, monetary measure of harm that they suffered from discriminatory conduct, and then you know, the person who did that to them is just going to be let off the hook. I don't think that's what justice for folks with disabilities looks like. in our state, asking for a no vote on the cow.
Seeing no further discussion, the motion is the adoption of S002 to House Bill 1239. Are there any no votes? Senator Weissman, Magnuson Janae, Kipp, Wallace, Marchman, Judah, Gonzalez, Amabile, Henriksen, Sullivan, Mr. Majority Leader, Colker, Exum, Roberts, Mullica. Any other no votes? I don't see anyone in the back row. Oh, Senator Ball. Please add the president. With a vote of 13 ayes, 17 noes, 0 absent, 5 excused, S02 to House Bill 1239 is lost. Further discussion. Seeing none, the motion is the adoption of the Committee of the Whole report. Are there any no votes? Senator Liston on the Committee of the Whole report? Committee of the Whole? Senator Baisley? Senator Rich? Any other no votes in the Committee of the Whole report? With a vote of 27 ayes, 3 noes, 0 absent, and 5 excused, Committee of the Whole report is adopted. Senate Bill 11 is amended, 50 is amended, 64 is amended, 292 and 295 passed second reading order, gross place counter for third reading and final passage. House Bill 17 is amended, 1017 is amended. 1209 is amended, 1239 is amended, 1279 is amended, 1321 passes second reading order, revised place counter, third reading and final passage. Senate Bill 288 laid over until 4/25/2025, retaining its place on the calendar. Consideration of House amendments to Senate bills. Majority Leader Rodriguez.
Thank you, Mr. President. I move that the consideration of House amendments to Senate bills calendar lay over until Friday, April 25th, 2025.
The motion is lay over the consideration of House amendments to Senate bills calendar Friday, April 25th, 2025. All those in favor say aye. Opposed, no. The ayes have it. The consideration of House amendments to Senate bills calendar will lay over until Friday, April 25th, 2025. Consideration of conference committee reports. Mr. Schaffler, please read the title to Senate Bill 229.
Mullica. Senator Mullica is not listening.
229.
You need to pay attention to this one.
Senate Bill 229 by Senators Kirkmeyer and Bridges and Representatives Byrd and Taggart concerning Medicaid reimbursement for community health workers and in connection therewith reducing an appropriation.
Senator Kirkmeyer.
Thank you, Mr. Chair, or, I'm sorry, thank you, Mr. President. Was reading chair in parens, sorry. Thank you,
It's all
Mr.
good.
President. I move that the Senate adopt the first report of the first conference committee on Senate Bill 25-229.
Any discussion? There is discussion? Senator Mullica.
Thank you, Mr. President. Really want to take this opportunity to thank the JBC for the work that you all did on this. I know you're missing one member here. And we heard this debate and we had this conversation while we were debating the long bill and the orbitals and really what these community health workers mean and the opportunity that we have here in Colorado to make sure that we are offering those wraparound services to our patients. And we know that the return on our investment on these, when Senator Simpson and I ran this bill, we heard how important this is going to be. And for the JBC to really work to find this compromise and to find these dollars to make sure that Colorado has this opportunity and the people of Colorado have this opportunity, I think speaks volumes to the work that you all do. And I appreciate you hearing how important this program is and really finding a way to make sure that, that it lives on, that we give it an opportunity. So thank you.
Further discussion? Seeing none, the motion is for the adoption of the first report of the first conference committee on Senate Bill 229. Are there any no votes? With a vote of 30 ayes, 0 noes, 0 absent, and 5 excused, the first report of the conference committee on Senate Bill 229 is adopted. Mr. Schaffler, please add Senators Winter and Cutter to the roll. Senator Kirkmeyer.
Thank you, Mr. President. I move for the repassage of Senate Bill 25-229.
Any further discussion? Seeing none, the motion is for the repassage of Senate Bill 229. Are there any no votes? Senators Rich, with a vote of 31 ayes, 1 no, 0 absent, 3 excused, Senate Bill 229 is repassed. Co-sponsors, Senators Malika, Exum, Michelson Janae, Cutter, Pelton R. Catlin, Simpson. Seeing no further co-sponsors, Mr. Schaffler, please read the title to House Bill 1006.
House Bill 1006 by Representatives Lukens and Hartsook and Senators Bridges and Colker concerning allowing a school district to lease district property for any term of years.
Senator Colker.
Thank you, Mr. President. I move that the Senate adopt the first report of the First Conference Committee on House Bill 1006.
Any discussion? Seeing none. The motions for the adoption of the first report of the First Conference Committee on House Bill 1006. Are there any no votes? With a vote of 32 ayes, 0 no, 0 absent, 3 excused, the first report of the First Conference Committee on House Bill 1006 is adopted. Senator Colker.
Thank you, Mr. President. I move for the repassage of House Bill 1006.
Seeing no further discussion, the motion is repassage of House Bill 1006. Are there any no votes? What? Mr. Minority Leader, Senators Frizzell, Pelton B., Bright, Carson, Catlin, Pelton R., Pelton R. again, Pelton R. for a third time, Pelton R. for, okay, we're going to keep going. Liston, Baisley, with a vote of 23 ayes, 9 noes, 0 absent, 3 excused. House Bill 1006 is repassed. Co-sponsors, Senator Colker, Mr. Schaffler, please read the title of Senate Bill 268.
Senate Bill 268 by Senators Bridges and Kirkmeyer and Representatives Byrd and Sirota concerning changes to money in the marijuana tax cash fund and in connection therewith reducing an appropriation.
Senator Kirkmeyer.
Thank you, Mr. President. Members, please don't pull a house here. I move that the Senate adopt the first report of the First Conference Committee on Senate Bill 268.
Further discussion? Seeing no further discussion, the motion is for the adoption of the first report of the First Conference Committee on Senate Bill 268 and to show the House how it's done. Are there any no votes? There is a no vote.
I'm kidding.
Yeah.
I wanted to give her a heart attack.
All your bills aren't going to get
Wouldn't
funded.
matter to me. I do cut a whole bunch of programs.
With a vote of 32 ayes, 0 no, 0 absent, and 3 excused, the first report of the First Conference Committee on Senate Bill 268 is adopted. Senator Kirkmeyer.
Thank you, Mr. President. Thank you, members. I move for the repassage of Senate Bill 25-268.
Seeing no further discussion, the motion is repassage of Senate Bill 268. Are there any no votes? With a vote of 32 ayes, 0 no, 0 absent, and 3 excused, Senate Bill 268 is repassed. Co-sponsors. Very good. Conference committee reports or conference committee appointments. In response to a request from the House, the lower chamber, for a conference committee on House Bill 1154, the Senate conferees are Senators Judah, Chair, Amabile, and Carson on the first conference committee on House Bill 1154. Senator Judah.
Thank you, Mr. President. I request that the Conference Committee on HB 1154 be given permission to go beyond the scope of the difference between the two houses.
The motion before the body is to grant permission to the conferees on the First Conference Committee on House Bill 1154 to go beyond the scope of the differences between the two houses. All those in favor say aye.
Aye.
Opposed, no. What? But the ayes have it, and permission is granted. Message from the House.
The House is adopted and returns herewith Senate Joint Resolution 22.
Introduction of bills.
Senate Bill 309 by Senator Simpson, Representative Brown, concerning authorization for the Legislative Council to approve the placement of nonpartisan legislative fellowships within the Legislative Council staff.
State Veteran Military Affairs.
Senate Bill 310 by Senators Kirkmeyer and Bridges and Representatives Byrd and Taggart concerning the implementation of Proposition 130. Senate Bill 311 by Senator Amabile and Kirkmeyer and Representatives Byrd and Taggart concerning the balances of inactive cash funds.
Appropriations.
Senate Bill 312 by Senators Amabile and Kirkmeyer and Representatives Byrd and Sirota concerning the use of money received from the Federal Coronavirus State Fiscal Recovery Fund and in connection therewith transferring the unspent state money that refinanced the money received from the Federal Coronavirus State Fiscal Recovery Fund, repealing the requirements for recruitment of healthcare professionals funded with refinanced money and making and reducing appropriations.
Appropriations.
House Bill 1122 by Representatives Leader and Richardson and Senator Sullivan and Liston concerning a requirement that a commercial motor vehicle have a human present when the commercial motor vehicle is being driven by an automated driving system.
Transportation and Energy.
House Bill 1146 by Representatives Byrd and Woog and Senators Kirkmeyer and Amabile concerning measures to ensure that sufficient juvenile detention beds are available to address juvenile crime in proportion to annual juvenile detention projections and in connection therewith making an appropriation.
Health and Human Services.
House Bill 1259 by Representatives Froelich and Brown and Senator Cutter and Doherty concerning assisted reproduction and in connection therewith adopting in vitro fertilization and other assisted reproduction and fertility protections and eliminating other administrative requirements.
Health and Human Services.
House Bill 1269 by Representatives Wilford and Valdez and Senators Ball and Kipp concerning building decarbonization measures and in connection therewith creating a building decarbonization enterprise and making an appropriation.
Finance.
House Bill 1315 by Representatives Sirota and Puglisi and Senators Weissman and Kirkmeyer concerning vacancies in the General Assembly and in connection therewith making an appropriation.
State Veterans and Military Affairs.
House Bill 1319 by Representatives Puglisi and Duran and Senators Kirkmeyer and Rodriguez concerning vacancies in the Office of County Commissioner and in connection therewith making an appropriation.
State Veteran and Military Affairs. Signing of bills.
The President has signed House Bill 1116, 1132, 1148, 1172, 1185, 1210, 1280, House Joint Memorial 1001, House Joint Resolution 1022, House Joint Resolution 1024, House Joint Resolution 1025. The President has signed Senate Bill 9, 31, 63, 125, 152, 164, 166, 177, 177, 178, 191, 199, 206, and 247.
Announcements. Senator Coleman.
Thank you, Madam President. Request a moment of personal privilege.
Granted.
Thank you, Madam President. I look forward to the fine I'm about to receive because as an individual that's in the chamber but not on the floor, and I want to wish them a very happy birthday. So I'm going to look at the camera and pretend like they're not in the gallery. Can we all join in and welcome and say happy birthday to Cindy Markwell, our senior advisor to the Secretary.
Happy birthday to you. Are you going to sing? Birthday to you.
Hey.
Happy birthday, dear Cindy.
Hey.
Happy birthday to you.
Hey.
Excellent. $5 fine.
What?
Senator Balka.
Thank you, Madam President. Members, Senate Health and Human Services Committee will be meeting upon the adjournment of the upon adjournment committees. We have a number of appointees as well as hearing House Bill 1213, Senate Bill 296, House Bill 1250, House Bill 1097, House Bill 1094, House Bill 1088, Senate Bill 301. Look forward to seeing you there.
Further announcements. Senator Kipp.
Yes, thank you. Members of the Senate Finance Committee, we will be meeting 15 minutes upon adjournment, which will be approximately 2:18. In the SCR 357 to hear 306, 1303, and 1274.
Senators. And Senator Exum.
Thank you, Madam President. Senate Local Government Housing will be meeting 15 minutes upon the adjournment of the upon adjournment committees. Thank you.
Senator Roberts.
Thank you, Madam President. Agriculture and Natural Resources Committee, we will meet upon adjournment of the upon adjournment committees in room 352. We have appointments for the State Board of Land Commissioners, followed by House Bill 1163 and House Bill 1318. And then I have another announcement, along with the good senator from Cheyenne Wells. You all should have received a flyer on your desk. Tomorrow is Sportsman's Day at the Capitol. which means a delicious lunch being served out on the east side of our building. And if we're anxiously awaiting, we have gotten word that our old good friend, the former senator from Newcastle, may be making an appearance at Sportsman's Day. So if you would like to see Commissioner Will, he will be down there. But we'll have some folks here tomorrow morning to honor sportsmen in Colorado, but wanted to make sure you all knew about lunch tomorrow.
But don't hold,
Senator Pelton R.
but don't hold Senator Will being here against.
That's right.
Senator
Yes,
Dillon
that's right.
and I.
All right, Senator Weissman.
Thank you, Madam President. This is to announce the business of the State Affairs Committee. 15 minutes after the gavel drops here on recess, we will meet in 352 to consider 4 bills, 1273 for action only, 1266, 1083, and 1327. Due to sponsor timing issues, we may need to mix up the order, but those will be the 4 bills we'll hear. See you up there.
Senator Amabile.
Thank you, Madam President Pro Tem. Just President, just Madam President. Okay, I have to find my app, and then I have to find the right one. Okay, so tomorrow we will be having appropriations at 8 a.m. across the street, and we will be hearing 1013, 1105, 1112, 17, 26, 84, 118, 120, 142, 153, 163, 285, 286, 290, and other bills as assigned. Be there or be square.
Okay. Senator Henriksen.
Thank you, Madam President. 15 minutes upon adjournment, Business, Labor, and Technology Committee will meet in the old Supreme Court for consideration of House Bill 1300 and House Bill 1330.
Senator Judah.
Thank you, Madam President. Members, I just want to introduce former representative from Arizona, Athena Salman. She's visiting us today and doing some trainings, if you will, but if you can all welcome her, I'd really appreciate it.
All right, Majority Leader Rodriguez.
Thank you, Madam President. Members, as a reminder, the final window to order General Assembly merchandise will close today. A link was sent to you on Tuesday to place your order. Orders placed during this window will not arrive until after the session. Contact Tammy at the front desk with any questions. Additionally, there is an annual inventory of state-owned equipment beginning tomorrow, Friday, April 25th. IT will be conducting a scan of your state-provided IT equipment, so this inventory, all state-owned technology, is required by the accounting team. Starting Friday, IT personnel will visit your office to visually verify your computers, desk phones, and iPads. The visits will be brief and only will take a couple of minutes, so please have your state-provided equipment readily available. If you're out of the office, IT will arrange for a later scan. With your permission, they will go record the equipment in your office. Colleagues, we are recessing to read bills across the desk later today, so on that, no need to return. Madam President, I move the Senate adjourn until I move the Senate recess until 2:30 p.m. today.
You have heard the motion. All those in favor say aye. Those opposed say no. And the Senate will stand in recess until 2:30 today.